The meeting of the General Laws and Technology Committee will come to order. We'll call the roll here on the machine. So,
you have a quorum, Mr. Chair.
thank you. We have a quorum, and we'll get started now. We do have a number of House members to present bills, but what I want to do is just to deal with a couple that will go by for the day at the beginning, and then we'll do the ones that are identical or similar there first, and then we'll get into going through the rest of the docket. By for the day, I'd like to propose House Bills 507 and 586 to go by for the day. Been requested on those two. All right, we have a motion to move to pass by for the day 507 and 586. All in favor say aye. 507, which is on page 1, and 586, which is page 9. Yeah, page 9 is on 586 is page 9 for members of the committee. So, all right, all in favor say aye.
Aye.
All opposed, no. All right, those two are by for the day. Now we'll go through the ones that are left that are have companions that are identical. House Bill 19 from Delegate Fowler, dealing with Virginia Public Procurement Act. This is identical to Senate Bill 210, which reported from the committee with a substitute of 13 to 0 to 1, and passed the Senate with the substitute, that same substitute, on a 37 to 3 vote. All right. Second. We have a motion. Wait a second. We need to yeah, this is identical, so that means it's already been fixed. All right. We have a motion to report. Is there a second? All right. We got a motion and a second to report House Bill 19. Let's vote on the board.
Ayes 11, noes 1.
All right, ayes 11, noes 1. That bill will be reported then. And all right. Then next we have House Bill 239 from Delegate Adams. That's dealing with Housing and Supportive Services Interagency Leadership Team Initiative. Yeah, it's identical to Senate Bill 263, which reported from the committee 14 to 0 with 1 abstention, and passed the Senate as amended 38 to 0.
Move to report.
All right, we got a motion and a second. If there's no further discussion or questions, we will vote on the board. So.
Ayes 12, noes 0.
All right, aye 12, no 0. That
Reeves votes aye.
all right, 13 to 0. So, all right. All right. Next one we have is House Bill 714 from Delegate Hayes. It's the Consumer Data Protection Act, and is identical to Senate Bill 534. Which reported from Finance and Appropriations with a substitute 13 to 2 with 1 abstention, and passed the Senate 38 to 1. It goes to appropriations, so we need to have a motion to report and re-refer to Finance and Appropriations.
So Mr. Chairman, they're identical at this point?
Yes.
Okay, thanks.
That's what my cheat sheet says here anyway. So, all right, we have a motion and a second to report and re-refer to Finance and Appropriations. If there's no further discussion, we'll vote on the board.
Ayes 14, noes 0.
Okay, that bill passes. Or reports and then goes to Finance. All right, next we have House Bill 718 from Delegate Fillicorn. It's related to the Virginia Board of Workforce Development Apprenticeship Programs. It's identical to Senate Bill 661, which reported 15 to 0, was re-referred to Finance, where it reported with a substitute 16 to 0, and passed the Senate 40 to 0.
Mr. Chairman,
Yes.
can I move to conform it to the substitute that left finance?
Well, I think that's what it is. That's what it is now.
Oh, that's what it is.
Yeah,
Okay,
They
well
have the
then,
same issue, same things here. All right,
Move to report and re-refer to finance.
right. Actually, this one is not, this one
Oh, never
doesn't say,
mind.
it's not on
Never
the
mind.
finance list, so.
to
So this one
report.
is just a motion to report. Okay, is there a second?
second.
All right, we will vote on, if there's no further discussion, we'll vote on the board, so.
Ayes 14, no, 0.
All right, ayes 14, no, 0, that bill is reported. Next is House Bill 727, Delegate Ward, Historical African American Cemeteries. This is identical to Senate Bill 23, which reported from this committee 15 to 0 and passed the Senate 40 to 0 as substituted.
Move to report.
Second.
All right, we got a motion and a second to report.
Got it.
You're looking good, so. If there's no further discussion, we'll vote on the board.
Ayes 15, no, 0.
All right, ayes 15, no, 0, that bill's reported, so. And next, we have House Bill 1102 from Delegate Ransone, gubernatorial appointments to boards, membership and terms. It's identical to Senate Bill 308, which reported from the committee 15 to 0 and passed the full Senate 40 to 0.
Move to report.
All right, there is a motion to report and a second. If there's no further discussion, we'll vote on the board.
Ayes 14, no, 0.
All right, as ayes 14, no, 0, 15, no, 0. We snuck the last vote in. So that bill is reported, and we'll go straight to the floor. Then we have House Bill 1300, which is Delegate Freitas. It's wait a second. Okay, this is renaming the Director of Diversity, Equity, and Inclusion as Director of Diversity, Opportunity, and Inclusion. That's identical to Senate Bill 735, which was passed by indefinitely by the committee. So,
Mr. Chairman, there's only one change to this one. Instead of Senator Ruff, it's Delegate Freitas, and I don't think that helps. So.
You're on a roll. So, yeah. So, all right. Is there a motion anyone wants to make? So. All right, we have a motion to pass by indefinitely and a second. If there's no further discussion, we'll vote on the board now. So,
Ayes 8, no, 7.
you were right. All right, thank you. So now we have House Bill 1303. And that is Delegate Williams is presenting that. Virginia Freedom of Information Act, Virginia Parole Board member votes, a bill we're very familiar with since we passed it 3 years in a row, I think. It's identical to Senate Bill 5, which is from Senator Suderline, and which reported 14 to 1 from this committee, and passed the Senate 37 to 3.
Move to report.
Okay.
All right, we got a motion and a second. If there's no further discussion, we'll.
And the finance.
Oh, yeah, then we need to go to finance on
Yes,
it.
sir.
Okay. You did say that, right?
I did, you didn't hear me.
Yeah, I know. My hearing's bad on that side, so. That will go to finance. So, all right, we'll vote on the board now.
Who's got Stewart's vote? Vogel?
Ayes 13, noes 2.
All right, ayes 13, noes 2. That is reported and re-referred to finance. All right, now we have a few that
Do you need me to tell him something? Do you need him to come back?
are similar. One is House Bill 282 from Delegate Coiner.
244.
Deals with the Department of Professional and Occupational Regulation. It's similar to Senate Bill 409, and so if someone wants, they could make a motion to conform it to Senate Bill 409.
So moved.
All right.
Unless, Mr. Chairman?
Do you want to address anything in particular on it?
Mr. Chair, we are working on, between the two bills, some changes. It might be best if it goes by for the day.
We certainly can do that if you would like.
Yes, please.
So,
Second.
all right, we got a motion and a second to pass it by for the day. All in favor, say aye. Aye. All right. And just make sure you show up next week, so. That'll be the last week, so your last chance there, so. Okay, House Bill 763 from Delegate Krizak on charitable gaming.
Mr. Chairman, that's the same as my Senate Bill 403,
Right.
and we're going to conform Delegate Krizak's bill to put my bill on top of it and conform his to my bill.
All right, we got a motion to conform to Senate Bill 403 and a second. All in favor, say aye.
Aye.
All opposed? So with Senate, it now looks like Senate Bill 403, except for Reeves is replaced by Krizak. So, if there's no further, for no further discussion, we can, we have a motion
Into finance.
and send it to finance. So, yes, you made it. You made the right motion. And so we have House Bill 763 to report, and we refer to finance. And if there's no further discussion, we will vote on the board.
Ayes 15, no zero.
15, no zero. And Delegate Fowler, we took care of, you were not here, so therefore we got your bill passed, so.
Really appreciate that. We had an amendment. Was that added on there too?
You have an amendment?
Yes.
We could take that up now, Mr. Chair, or we could do it on the floor. Yeah, a floor amendment maybe?
You want me just to, Richard voted?
Well, we could redo. We could bring it back up.
Mr. Chairman?
Yes.
Having voted on the prevailing side by which we passed
House Bill 19.
House Bill 19, I would like to ask that that vote be reconsidered.
All right, we will vote now. The motion and a second to reconsider House Bill 19. It's all vote on the board, so. That's right.
Ayes 15, no zero.
All right, ayes 15, no zero. Okay, do you have an
Yes, sir,
amendment
Mr. Chairman. We have particularly a line amendment on line 71 after the enclosed version, after provisions, we wanted to strike the words, three little words, of subsection B. And what this does is it's a technical nature and it just ensures that all of 2.2, 4376.2 expire on June 30th, 2027 instead of just subsection B. And that's strictly what the amendment does. And that's it.
All right. So it strikes three words in there, is that what it does?
Yes,
Okay.
yes, Mr. Chairman. Yep.
All right, do you, staff have that amendment?
Mr. Chair, the line amendment should be available on LIS for everyone to view right now.
Was that?
The line amendment should be available on LIS right now for
Okay.
everybody. Yep.
All right, there's a motion to adopt the line amendment. Is there a second? All right, all in favor of adopting the line amendment, say aye. Aye. And all opposed, no. All right, do we have a motion to report the bill? Report as amended. All right, we had a motion and a second to report as amended. Yes.
Can we just get some clarification? The agenda says it's identical to SB 210. Who was SB 210? Which bill was that?
It's Senator Peterson.
Oh, Chap's bill, okay.
Yes, sir.
Thank you.
All right, we'll make sure he's aware you amended.
Yeah, we'll take care of his over on the other side.
Okay, good, all right.
Yeah.
All right, if there's no further discussion, we'll vote on the board.
Ayes 14, noes 1.
Thank you, Mr. Chairman.
All
Always
right.
a pleasure.
Thank you. Always so, thank you.
Thank you.
All right. Yeah, did we vote, did we vote on 763 yet?
Yes.
Yeah, that's what I thought we did, okay. All right, and then next is House Bill 970, Delegate O'Quinn. And this is Public Agencies, Privacy of Personal Information. It's identical to the second substitute of Senate Bill 324. All right.
Mr.
And
Chair.
that was what I think passed in the end in the Senate. So.
Mr. Chair, just to
that
clarify,
correct? Yes.
that is the same bill of mine that passed And I tried to make it over to the House side to make one amendment, or actually two amendments that we agreed on, but I didn't get there in time. So we're going to
You're a little
fix
slow,
it.
is
We're
that
going
what
to,
you
I was a little slow. I got there and they had already conformed and voted it out. So we're going to try to fix it now.
Okay.
Thank you, Mr. Chair.
Proceed, Delegate O'Quinn.
Yes, sir, Mr. Chairman. I do have a substitute for this bill, and I would be happy to tell you the changes that are included that would make it slightly different than Senator Vogel's, but are changes that we have agreed on with the stakeholders.
All right.
So we've had some very minor tweaks that have come from VDOT, DMV, State Corporation Commission, the Supreme Court. The biggest change is on line 109 of the substitute, which changes personal information to personal donor information. That change is reflected in the bill. And then in line 95, it ensures that donors to nonprofits that are established in support of a government entity are excluded from protection since they are in direct support of a government entity. However, there was some language, or there was some concern raised by college foundations as to whether this would affect them. The answer is no, it does not. So those are the changes that that we have had brought to us, and makes it slightly different from Senator Vogel's bill, but the same nonetheless.
All right. Does anyone want to adopt it? You have the amendments? All right.
Second.
Got the substitute. All right. And this was not on the finance list, so if anyone wants to make a motion, now's the time. So, all right. I want to report as amended. All in favor? Well, we will vote on the board. So.
Ayes 15, no 0.
All right. Ayes 15, no 0.
Thank you, Mr.
Both
Chairman.
reported, so, thank you. And next is House Bill 1265, which is Delegate Supermanian, and deals with the Department of Housing and Community Development Broadband Affordability Plan. It's identical to Senate Bill 716, except for a title change, which doesn't impact the law. And that reported from the committee on a 15-0 vote and passed the Senate 40-0.
Yeah, Mr. Chair, I do have a couple technical amendments.
All right.
Yeah, line 7, basically striking after affordability and equity, just to change the title to reflect the bill. It's changed since it was first introduced. And then second, on line 19, apparently we need to strike one of the spaces. There's an extra space, but DLS asked us to do that.
All right.
So I moved the amendments. Or I hope the committee can move the amendments. I know.
All right, we have two line amendments under consideration here. We'll deal with them in a block. All in favor of accepting the line amendments, say yes.
Yes.
All right, all opposed, no. All right, the line amendments have been adopted. So,
Report is amended.
okay, we'll report it as amended. All right, if there's no further discussion, we'll vote on the board.
Ayes 15, no 0.
All right. All right.
Bill, too, if you want me to go next.
Was it, we'll come back to you on the other one, so, yeah, that sounds fine, so. All right, I think we finished all our identical and similar ones. There is one other that we propose re-refer to a Delegate Hope's House Bill 677 on posting of notices. Electronic posting was a recommendation of the Boyd Grace Conference, and Judiciary has asked to take a look at this so we could act on the bill and refer it, or re-refer it, or just re-refer it.
Mr. Chairman, I move
Okay.
that House Bill 677 be re-referred to the House Committee of Judiciary.
All right.
Second.
All right, there's a motion and a second to re-refer 677 to the Committee on the Judiciary. If there is no further discussion, we'll vote on the board on that motion.
Ayes 15, no 0.
Yeah, and then we have one other to re-refer, and that's House Bill 1091 from Delegate Wilt, dealing with the Virginia Public Procurement Act, project labor agreements, and that has been requested by Commerce and Labor, which usually handles those types of issues there, so rather than...
That bill be referred to committee on
Refer to finance.
All right, is there a second? All right, we got a motion and a second to re-refer House Bill 1091 to Commerce and Labor.
Oh, okay.
And if there's no further discussion, we'll vote on the board. All right.
Ayes 15, no 0.
All right, we're 15-0. The vote's 15-0. The bill will be re-referred to Commerce and Labor then. So, all right, now we will take the people on the sign-up list in the order in which they signed up. Delegate March.
150.
Thank you, Mr. Chair. Speaking to House Bill 150, addresses the need for any local public body to publish approved minutes for public viewing within 7 working days of the minutes approval. This bill amends the Code of Virginia by adding Section 2.2 through 3707.2 relating to the Freedom of Information Act. We still have localities in the Commonwealth where the public must specifically request meeting minutes, and minutes are not readily available. I'm requesting of this body to help bring more transparency to our constituents by making approved minutes posted on its website, or if they do not have a website, they shall make copies of minutes and post in a prominent public location pursuant to subdivision C2 of 2.2 through 3707, which is at the office of the clerk, or in the case of no clerk, the office of the chief administrator. Thank you.
All right, are there any questions of the patron?
Mr. Chairman.
All right, Senator Reeves.
Doug, is this your first bill before the Senate?
Yes, sir.
Can you clarify on, for me, on line 16, if you work on Saturdays, is that considered part of the 7 working days?
No, sir.
Thank you.
All right, any other questions of the patrons? So,
Mr. Chairman.
yes.
How many, thank you, Mr. Chairman. How many copies do you have to make?
Sir, that is not specified. 1.
Mr. Chairman, I think we have a grievous error here. That should be copy, not copies. We may have a problem
Mr. Chair,
here.
in Title I, we do say that the plural and the singular are incorporated into each other.
Mr. Chairman, you owe council a big thank you there.
All right, are there a long list of people in opposition to this bill, I presume? So, anybody wish to comment either for or against the bill?
If you're in the Zoom room and wish to speak in regards to this bill, please raise your hand electronically now. Mr. Chairman, we have one speaker, Vic Nichols.
All right. Please comment. We'll have 1 minute.
Thank you. I've had this happen to me, so yes, it would be appreciated if we could get this passed into law. Thank you.
Thank you. So, all right, we got a motion.
Substitute motion PPI. No, I'm joking.
Move the report, Mr. Chairman.
All right, we've already had 2 people move to report. Does anybody want to second it? So.
Second.
All right, we now have a motion to report and a second as well. If there's no further discussion, we will. This is the first bill of this particular delegate, so we'll vote on the board. So. You got an abstention, but. All right.
Ayes 15, no 0.
Ayes 15, no 0. Congratulations.
Thank you.
All right. All right, Delegate Les Adams. Are you here?
He's chairing across.
Oh, go across your hall. Okay, Delegate Torian. You have a few bills, I think, so.
Yes, sir. Good afternoon, Mr. Chairman. I have 3 bills. First one before you is HB 814. Mr. Chairman and committee,
House Bill 814 directs the Department of Small Business and Supplier Diversity to annually review and provide feedback on the state agency's plans to enhance procurement from small, women-owned, and minority-owned businesses. This policy proposal was developed by the Virginia Minority Business Commission.
All right. Any questions of the patron? No, not quite. Not by a little more than a decade, so yeah. All right, is there anyone who wishes to speak either in favor or in opposition on this bill?
If you're in the Zoom room and wish to speak in regards to this bill, please raise your hand electronically now.
Move to report. Second.
All right, we have a motion and a second. Nobody's stepped forward to speak. If there's no further discussion, we will vote on the board. So.
Ayes 15, no 0.
Ayes 15, no 0. You're on a roll, so.
Thank you, Mr. Chairman. Mr. Chairman, the next bill is House Bill 815. House Bill 815 directs the Department of Small Business and Supplier Diversity to administer a mentorship pilot program under which established businesses or industry sector experts act as mentors to startup women-owned or minority-owned businesses. Mr. Chairman, the policy proposal was a key recommendation that comes to us by the Virginia Minority Business Commission.
All right, are there any questions of the patron? All right, will anybody in the audience wish to speak either in favor or opposed to this bill?
If you're in the Zoom room and wish to speak in regards to this bill, please raise your hand electronically now. Mr. Chairman, there are no speakers.
All right, is there a motion? Second. All right, got a motion and a second to report. This one does have to go upstairs to and re-refer to finance. All right, we have a motion to report and re-refer to finance. We'll vote on the board.
Ayes 15, no 0.
All right. Next.
Thank you, Mr. Chairman. Mr. Chairman, House Bill 820. House Bill 820 asks the Department of Small Businesses and Supplier Diversity to conduct a disparity study every 5 years, the next no later than January 1, 2026. And also, Mr. Chairman, this policy proposal was developed by the Virginia Minority Business Commission. That recommendation.
All right. Are there any questions of the patron? Anyone wish to speak either in support or opposition to the bill?
If you're in the Zoom room and wish to speak in regards to this bill, please raise your hand electronically now. Mr. Chairman, there are no speakers.
All right. All right, we have a motion and a second, and this one also has to go to, this one goes.
And re-refer to finance.
Yeah. All right. We'll vote on the board then.
Ayes 14, noes 1.
All right, ayes 14, noes 1. All right, thank you. I think that's all your bills.
Thank you, Mr. Chairman.
Really?
All right, next up is Delegate Coiner. Proceed.
Thank you, Mr. Chair. Mr. Chair, I wasn't sure if my House Bill 281 went through before I came in the room. It's similar to Senator Evans' Senate Bill 311. Is that?
281.
I didn't know if you all took it up as being identical or if that's what I should present now.
281 and 284 are on the regular list.
Great.
So.
Thank you, Mr. Chair.
Okay.
My House Bill 281 is identical to Senator Evans' Senate Bill 311. This, the first part of House Bill 281 codifies a duty for a real estate licensee to disclose to other parties in the transaction any ownership interest that they have. The second part of this bill does require disclosure of any lis pendens that is existing. I'd be happy to answer any questions that you have.
Mr. Chairman?
All right, Senator Evans.
My bill had been amended in the Courts Committee. Do you know, is your bill identical now in that format?
It is my understanding that it is, Senator.
Okay, thank you.
311, she said.
281.
All right, they are identical.
I would move to report.
All right, there's a motion and a second to report. And this one is, okay, we're good there. All right, if there are no further questions, we'll vote on the board.
Ayes 15, no zero.
Ayes 15, no zero, that bill is reported, so. All right, and then you have 284.
Yes, Mr. Chair.
All right.
I do have a substitute to bring before the committee.
Okay. All right, we have a motion to adopt the substitute, and a second. All in favor, say aye.
Aye.
All opposed, no. All right, that's before us now.
Thank you, Mr. Chair. I'll explain the bill and then the purpose of the substitute. So the bill does establish, we currently, appraisers in Virginia do have required continuing education hours. This bill would require that of the existing hours, many of which are elective choices, 2 of those hours would be required in fair housing. The substitute before you adds fair housing or appraisal bias. We do know that there are courses being developed in each category, and so it would allow for in either category. The substitute also, the bill originally would have everything go into effect immediately in July. This would extend it through, not starting until July 1st, 2023, so that folks who are in the middle of getting those licenses renewed wouldn't be caught up and would be aware that this was changing, would be required for their license. So that's what the substitute does.
All right, thank you. Does anybody have any questions of the patron on the substitute? All right. Yeah, we adopted the substitute, yeah. All right, we have a motion to report and a second, and this
Finance.
finance, okay. All right. All right, we will vote on the board.
Ayes 15, no zero.
Ayes 15, no zero. The bill will be reported and we
Thank you,
refer to
Mr. Chair.
finance, so. All right. Next is Delegate Supermarian. Supermanian. Yeah.
Thank you, Mr. Chair. So this is a new bill. It's HB 964. So essentially what we're doing here is we're directing state entities who are requesting bids on contracts to provide a digital option for submitting bids through, what right now is a pre-existing EEVA system. I do have an amendment to this as well. And the amendment is basically on line 18. We're basically going to allow DGS discretion to grant exemptions. There was VDOT in particular came to us and said that there are few programs where the providing a digital option may not be, they have their own system and providing a digital option may not make sense in those situations. So I'm happy to answer questions. We do have someone here to testify in favor of the bill as well.
All right. Okay.
Can you tell me what the amendments are?
Yes, line 18, the director of DGS or his or her designee may grant an exemption from such requirement at the request of a state public body and upon a showing of good cause.
All right. All in favor of adopting the amendment, say aye.
Aye.
All opposed, no. All right. That amendment is adopted. All right. Is there anyone who wishes to testify in favor? Okay.
Good afternoon. My name is Maggie Woodward, and I'm a third-year law student at the University of Virginia. Through a course, I worked with a delegate to develop this legislation. I just wanted to emphasize one quick point, which is that the pandemic has already helped agencies revise their practices and consider adopting more electronic proposals. So HB 964 really capitalizes on that momentum. At the same time, it recognizes that agencies might need some time to develop their procedures and really put things in place that will work going forward for them. So it has a delayed implementation date of July 2023. It makes good sense, and I urge you to vote for it. Thank you.
All right. Anybody in opposition?
If you're in the Zoom room and wish to speak in regards to this bill, please raise your hand electronically now. Mr. Chairman, there are no speakers.
All right.
Mr. Chairman,
Yes.
can that third-year law student apply to DLS? Because we need some people to find this stuff.
We will be hiring in the spring.
You got practice already, so good. All right, we have a motion and a second to report the bill. All right, if there's no further discussion, we'll vote on the board.
Ayes 15, no zero.
Ayes 15, no zero. The bill's awarded.
Thank you, Mr. Chair.
All right. Delegate Bell.
Chair, members of the committee, good afternoon.
Yep.
The bill I have is House Bill 734. I'm not aware if there being a Senate analog, so this, so to speak, is a new
there
issue
was
for
not.
you all.
I mean, obviously, we've dealt with the issue the last
Yes,
couple
sir.
of years. So.
Of course. All right. So, Mr. Chair, members of the committee, this bill would amend the FOIA changes that were made last year and went into effect on July 1. You might recall there was a bill that opened up police investigatory files to FOIA and required their production to anybody. And then there was a modest carve-out that said images of the crime victim, him or herself, or that could identify the victim, himself or herself, would not be produced, but otherwise they would all be produced. Shortly after the law took effect, our local police department, our police department received inquiries with regards to two very high-profile rape murders that we had involving a defendant named Jesse Matthews. I don't know how much statewide profile they had, but he murdered a Virginia Tech student, Morgan Harrington, and then subsequently murdered a UVA student, Hannah Graham. And the parents had been approached about participating in a made-for-TV movie. They refused, and the guy said, fine, and FOIA'd the information with the intention of using the videos, the photos, the transcripts, the police report in his movie. And when the police department received this FOIA demand, they recognized the extent of this. Mr. Chair, I would identify three potential issues here. The most obvious would be that crime victims are not part of the government agency. They didn't choose to take a job where they're creating government records. They're being dragged in this case, because of the deaths of their daughters. All they want to do is be left alone. The idea that their records would be used for this is atrocious. It's obscene. The second is there's no limit to this. Once we started thinking about it, once the public really internalizes that they can get everything, this will not end at made-for-TV movies. It'll be on TikTok videos. It'll be on Facebook. They'll be making YouTubes. The Harringtons are going to testify briefly, and they will tell you they've received communications from people making fan fiction, about their daughter's last minutes. It's pornographic kind of things. And then third, if you are a witness who saw something, talked to the officers, and were promised that won't use it in court, it will never come up, that is no longer much protection, because someone across the street can get the whole file, not just see what you said and how you said it, to whom you said it. They can actually get the video if it's a video case. Mr. Chair, what the bill does is it rolls back the expansion from last year to the victims themselves. So the victim would still have access to the file. If the victim was deceased, it would be the victim's immediate family. If the victim is a minor, it would be the parents. And we also allow for FOIA for those lawyers who are seeking a writ of actual innocence. Usually they have other avenues to get the records other than FOIA, but we do leave that as a carve-out for this. Mr. Chair, the only other thing we add is we add a specific injunction option for victims who the records are nonetheless being produced. At least they get a chance to go to court and say, before this hits the internet and is out forever, we'd like to have a chance to enjoin it. Mr. Chair, that's the bill. There's support and opposition online. My understanding is testimony from the two families who were directly affected and the police officer who got the FOIA request. Thank you, Mr. Chair.
All right, are there questions of the patron?
Mr. Chairman.
Yes, Senator Bell.
Mr. Chairman, we met earlier today, and I appreciate you talking about this bill. The one question I thought of, and I apologize for not asking in advance, what would be, is there some protection if the alleged perpetrator would be a relative and would be requesting such information? Has that been addressed somewhere?
Yeah, and it was someone else brought that up. I don't claim pride of authorship, but in the victim section, it says the victim, and then if the victim is deceased, immediate family, and then if the victim is a minor, that the guardian is not a person of interest or a suspect in the criminal investigation or proceeding. Now, I did not include that language in the family. We certainly could if that would be something that the gentleman would like to see if is otherwise interested in the bill.
Mr. Chairman, that I would suggest that we amend it to include the family, if the family is the person who would be accused of the crime against the victim, because this information, I think, could possibly be abused. I'm not sure how the best way to word that for council, but.
Mr. Chair.
Yes,
So,
Delegate Bell.
if I might suggest to council, on lines 98 and 99 is where we say it is not a person of interest or a suspect in the criminal investigation or proceeding. That language could be added not just to where it is, which is tied to a parent who is doing it on behalf of a child, but it could be added to the family language where that appears. I think it appears in two other places.
All right, you want to bring that amendment?
So moved. Second.
All right, a motion and a second to add that amendment. Any discussion on that? All in favor say aye.
Aye.
All opposed, no. All right, that amendment's been adopted then. Yes, Senator Eben.
For Delegate Bell.
Yes, sir.
This came from a Commonwealth's attorney, so I'm not an attorney, and you're the chair of the Courts Committee, so you'll be able to understand this better than perhaps I present it. But as a technical matter, she said it needs to be expanded to any post-conviction counsel, not just innocence writ, at any stage of investigation litigation, since the claims are developed in investigations and FOIAing something after filing a court appearance is too late. And the limitation on sharing sounds like it might preclude use in litigation. She also felt that the return time was too short because these cases can take years and counsels change.
Those are, Mr. Chairman, if I might reply, those are two different things. So what she is saying, there are different ways that lawyers post-trial can get records. Now, in most cases, FOIA is not the avenue that they use, but if the committee wanted, if that was something the committee wanted to do, you could do it the same way that we're doing it for writs of innocence. The families have said the issue is never the lawyers. The issue is, again, TBS, the person across the street, the guy who wants to see as many disgusting pictures as he can and put them on, again, on TikTok. The timing would also be something that we just pick. I mean, it's a new proceeding. We just pick numbers out of the air. It would certainly be possible to extend the length of time that they could look at them before they had to return them. As everybody knows, once we have an internet, once it gets out, it's gone. There's no getting it back. And there's an article actually in the Post today about this very problem where the father's trying to get, in those cases, the actual pictures of his daughter, doing all sorts of copyright laws and other things. We're trying to get there before it gets there. I would have no objection to that if the gentleman wanted to include other.
Well, I'm not sure that I have extreme sympathy for the family. I'm not sure that I favor the bill, but I think if we do pass a bill, that it would be helpful to have this in here. I would tend to favor an approach that would limit the use of photographs or recordings from being released outside of to anyone, perhaps that they could, anyone who's not an attorney, the photographs or recordings, those are the most things that these salacious TV movie producers might use. But I don't know that I favor the full bill, but I think that it would be wise to amend it in that way if you're open to it.
I would say that, and Mr. Chair, at the appropriate time, they're watching and listening. They may actually have some thoughts directly on this.
I spoke to them, and
what they have said to me is it was never the lawyers that caused the trouble, but they really, one of them, stuff they haven't even looked at. You don't have to look at the file, and their neighbors are going to see it, and they'll see it on the TV. So I would not object to that if that was something that the committees will wish to be.
Okay, well, is that an amendment council can construct?
I think they're talking about habeas and post.
Thank you, Mr. Chairman. Senator Eben, if I could get a little bit of clarification on the last issue coming from the Commonwealth's attorneys. But yeah, we could definitely put those together.
The first part, I guess, that you've already got is expanding it to any post-conviction counsel, not innocence writ, at any stage of the investigation litigation, right? You've got that part?
Mr. Chair, I feel like I'm
Delegate Bell.
The fourth least important lawyer talking about this. It may be that for direct appeal, of course, there's all sorts of existent discovery in place that is probably both arguably better and more proper. I think, I don't want to speak for someone who spoke through Mr. Eben to me, to you, but I think they're talking about habeas, if I were guessing.
Yeah, I would want to just make sure before we did something on the fly, but I would say, we could do amendments in kind and then before the floor we'll do that.
Yeah, yeah.
Mr. Chairman,
All right, yes. Senator Locke.
when this issue came before the FOIA Council, some of the stricken language it was put in Delegate Hurst's legislation. And the reason that it was put there was because of a family member whose wife was killed in Virginia Beach. So I think, you know, we get into a situation where you have one family member who wants all of this information to, you know,
Right,
and then on the other hand, we have family members who don't want it. So
and this would give every family member that wanted it could get it. Now, not someone who's not in the immediate family would not, and so, and council can correct me, that's certainly my read on it, would be if you and I are family and Senator Reeves is the deceased, you want it, you get it. I don't. But Senator McPike would not have any privilege to that because he's not a family member or a lawyer working on, as it's written, writ of innocence, or if it's expanded to subsequent things. Now, the current law does. Current law says family, friends, neighbor, stranger, all of it. And this is an attempt to try to not repeal the law that passed, but to amend back some of it that's causing what may or may not be an unintended consequence, but is a consequence.
okay.
Anything further, Senator Locke?
I'm just trying to be clear on what's being changed.
Those members who are not in the, we'll just call them the victim grouping, and those people not in what we're now creating as a lawyer grouping would not have access to these records pursuant to FOIA. That would be the Commonwealth could, like they could before July 1st, could produce, and then it includes a provision for these family members to go get an injunction. But that's the part that's changing back. Is that it?
All right.
Mr. Chair.
Yes, Senator Kiggins.
I just had a comment about especially the Virginia Beach piece. As the senator from Virginia Beach, I mean, one reason I voted in support of this bill last year was because of the voices of the families, the families of the victims from the Virginia Beach shooting.
Right.
And they are the ones that, yes, were requesting more information, felt like their questions weren't being answered, so I supported it then. But in hindsight and having looked at what Delegate Bell has addressed as some of kind of the unintended consequences that have happened as a result, I mean, I support this bill. I think it's a good idea. It just, you know, we always say puts the guardrails on it, but I think that just limiting that to really the people who need it, it will still answer questions for those families from that Virginia Beach shooting. So I still support the premise of the bill, but I think that this is a good direction to take it.
All right.
Mr. Chairman.
Senator Stewart.
Just briefly, Senator Locke is right. We spent a lot of time on this, but we had difficulty with it in the FOIA Council, and it was more of a divided vote than I like to see. And I'm so reluctant to say this because I don't want to swell Delegate Bell's head, but I think he actually did a better job with this than the FOIA Council did. I don't know that I'm going to say that many times, Delegate Bell.
I don't know that's true. I think we have some additional
He has done a good
information.
job with threading the needle on this one and giving the families access that should have it, for what it's worth.
All right. Why don't we, if there's no further discussion, we'll move to public testimony now.
Good afternoon, Mr. Chairman and members of General Laws Committee. My name is Bethany Harrison. I'm the Commonwealth's Attorney for the City of Lynchburg here on behalf of the Virginia Association of Commonwealth's Attorneys in support of House Bill 734. Last session, when this new code section was passed, 2.2-3706.1, the idea was to give more access for criminal investigative file material, the guts of the file, to attorneys for post-conviction relief and for victims of crime. And that's really what this bill reflects, as you've already pointed out. Those are the main groups that we're focused on here. And I want to echo the comments about the attorneys for post-conviction relief are not the issue. We're not concerned with that. They have their own ethical rules they have to follow. So giving this material over for our post-conviction relief methods or reasons is fine with us. But what this bill does do is add protections for our victims of crime. Currently, under the law, they have no say about what is released. This bill allows for them to have a say about material information that either reflects the most horrendous experience of their life or the gruesome details of the demise of their loved one. We, in the Commonwealth Attorney's Office in Lynchburg, I know when we receive these requests, we notify victims of crime just to let them know, or surviving family members to let them know it's being released. But beyond that, there's nothing they can do. This bill would require notice to those victims of crime, as well as it gives them a remedy if they want to prevent the release. Currently, I would imagine, I don't practice civil law, but I would imagine victims could apply for an injunction, but this legislative body speaks through its laws. And right now, all the laws of FOIA say err on the side of disclosure. When a victim, if they're able, this bill passes, the victim would be able to come to court, and instead of having all the laws saying err on the side of disclosure, this bill would instead tell the judges that there are factors to be considered, that we are to weigh the considerations, the privacy interests, the emotional health and well-being of the surviving family members or victims of crime before releasing this material. So it would empower our victims of crime here while still serving the same purposes of releasing criminal investigative file material to those who want or need the information for post-conviction relief. When it comes to media access, I just want to point out that with Commonwealth attorneys, we're elected officials, we're public officials. We regularly give interviews to the media. We have a duty to be open and transparent with our constituents, with our locality. I think you have a great detriment to yourself if you're not. And really, all those questions are FOIA requests. There's nothing that requires us to give those interviews. But anytime someone asks, we give it, and we've been doing that well before this law changed. So I don't think you really see any detrimental impact except for some of these requests where people are looking for the nitty-gritty details, the TV producers, the podcast producers. I've received all kinds of requests since July 1st, some from the Innocence Project, insurance companies, lawyers looking to file a civil lawsuit and they want to get the criminal investigative file material. I've also received a request from a divorcee who wanted the material on his ex-wife, what she said in a dangerous dog case about the family dog and what happened there, so he could use that material whatever way he saw fit. I don't really think that's what we intended in opening up the laws here. I think with this bill, VACA supports because it would narrow it down to those victims and protect them. We ask that you vote yes for this bill, to not send it for a study, because any period of time we continue forward, we're leaving those victims exposed. Thank you.
Any questions of the speaker? All right, thank you. Anybody else to testify?
If you're in the Zoom room and wish to speak in regards to this bill, please raise your hand electronically now.
Mr. Chairman, members of the committee, I'm Elizabeth Hobbs with the Virginia Sheriff's Association, and we are
Come a little closer to the microphone.
We are in support of this bill. As mentioned by a representative for VACA, it is a bill that supports victims' rights to information, and rights to privacy. And that is an important factor when you're dealing with these particular investigative files, which are hitting at the heart of the worst day that victims have had in their whole life, in protecting their right to have access to that information and to limit the access that anyone might be gaining for their own personal and for public disclosure. And so certainly we're in favor of this particular nuanced bill covering all of those protections. Thank you.
All right. Anybody else to speak on this? All right.
Mr. Chairman, there are multiple individuals online wishing to speak.
Okay. Let me have the ones that are in the room first come forward and speak, and then we'll get the ones on the line. So.
Thank you, Mr. Chairman, members of the committee. I'm Megan Ryan with the Coalition for Open Government, and Delegate Bell did set out, the basic history of why we're here, but I wanted to set it out again in a little bit starker detail. So from 2020 prior, we had decades of the law where it said any investigative file, whether it was open, closed, whatever, any investigative file could be withheld at the custodian's discretion. We're talking both police and prosecutors. And what we found was, because it's a lot easier to just say no instead of to actually go through the file, in almost every case, anytime anyone asked for a file, even if it was closed, they would be denied access. So last year, this bill came and said, okay, we want to try to balance the scales a little bit more, where we are going to provide access to some closed investigative files. But we're not saying every file, and we're not saying everything in every file, because we're also saying in this bill as it exists now, in the law as it exists as of 2021, we're saying no photos, no photos that depict a victim. Those actually cannot be released. That says no. It also says that there are 6 circumstances that you may, as a prosecutor or as the police department, you can still say no to release of those records. If it invades privacy, if it could perhaps injure or lead to threaten someone's public safety or personal safety. There are 6 other categories that are in existing law right now. If you're looking at the bill, those are on line 60 through 69, excuse me. Those are already written into the law, so there is protection for releasing not just the photos, as was mentioned, but other files in the giant case file for any particular incident. So that's what we now had a balance. And so now that we have this bill being proposed, we have completely shifted the balance again in favor, almost 100% in favor of the victims, and we're back to discretion for anybody else, everybody else. So essentially we're going back to no access again, because we learned prior to 2021, that if given the chance to withhold their file, they're going to be withheld. So this includes not only these cases where there are gruesome details, which we all agree are horrible and should not, be bandied around with abandon, but this is also including cases that involve crimes that are not violent. We are saying you also cannot get any files related to any crimes having to do with property crimes, drug crimes, computer fraud, instances where people have been charged with crime or arrested but then never actually charged. It includes files where a police officer has been decertified, and groups like the NAACP, who mentioned in Hanover County this week that they're interested in reviewing the case files of someone who has been decertified. Those are not going to be accessible anymore. So we just think that if there are some protections that need to be built in that are in addition to what is already here for victims of gruesome crimes, let's address that problem, but let's not throw out all this access that we have been able to achieve and that has been used by people, by journalists, by historians, by families of both victims and defendants, as well as witnesses that I've been contacted by. And let's, if we're going to study this, I think we should study it at the FOIA Council, or I would ask that you not pass the bill. Thank you.
All right, thank you.
Mr. Chairman, Catherine Ford with the Virginia Press Association. We oppose this bill. Permanently closing police files to the public unnecessarily shutters access to information from publicly funded agencies and is a step backwards in the realization that police transparency is crucial to justice and fairness. Depictions of victims and witnesses can already be easily redacted and withheld under the current law without precluding access to all information. And this bill solidly moves Virginia in the wrong direction. Protecting privacy while providing government transparency is a balancing act, and this bill does the first while eliminating the second. We hope you'll oppose the bill. Thank you.
All right. Can we take the people who are online?
Mr. Chairman, there is an issue on the Zoom at the moment. I'm not sure if they can hear us, but Jill and Dan Harrington, please unmute and begin your testimony. Mr. Chairman, yeah, the Zoom is down, but we will get it fixed shortly.
All right.
Mr. Chairman, could I ask a question during that meantime?
Sure.
I'm not sure if Delegate Bell or if the lady from the Commonwealth's attorney, but my question is, if the last speaker said that these protections are already there, then why are we having the problems that were explained over the past year?
Well, they're not. They're not there. I mean, this is a hard bill. There's good people on both sides, and the question is, where do we draw the line with respect to the previous speaker? Right now, it is exactly where someone who wants to review the files and do whatever they want with them has it. She's right that it doesn't have the photo of the victim. It has nothing to do with the pool of blood or the broken down door or all the other things that come with it, picture of the gun, and in a case like we're talking about with the Harringtons and the Grahams, it doesn't offer anything because it says you can't offer information that helps identify them. Everyone on the East Coast knows who they are. Everyone in this room knows who they are. When they do a TBS show with their names on it, there's nothing about the file that you can help. Now, I understand this is rolling back certain things. There are people that want to get access to these files, many of them for good reasons, some of them for malicious reasons. And I think we have to decide how we're going to treat these records. And the idea that we have government records and they're open, I think, is a good thing. I mean, that's something that presumably is all point of FOIA. These are records that were created by a government actor, but they contain the information within, not from government actors, not from people that went down to City Hall and made this is not people who chose to engage in their government, knew their records would be part of what some TBS guy is going to put on TV. These are people that were victimized by crime and just want to be left alone. And the so-called protections are just not there. I want to keep talking. So this would be by my lights, we went this way, and we've now got a chance with some additional evidence, and I appreciate what Senator Stewart said, but I don't think it's knowing more. It's just we have a chance to see what's actually happening. This will be a chance to go back and say victims should still get it. Counsel's attorneys can still do it, just like they did before if they wish. We'll have an injunction procedure for victims who feel that they're still being taken advantage of, and that's what the bill does. But it's a policy decision.
The delegate.
How are we going to have the people testify on Zoom now?
Mr. Chairman, the Zoom is working again, so Jill and Dan Harrington, please unmute and begin your testimony. Mr. and Mrs. Harrington, please unmute and begin your testimony. Okay. Matthew Harden, please unmute and begin your testimony. Mr. Harden, please begin your testimony. Mr. Chairman, the Zoom is glitching again. Apologies.
All right. Yeah, Senator Evan. Senator Evan.
Yeah, just want to ask Delegate Bell a question, not Senator Bell.
Yes, sir.
I understand what you're trying to do because of the salacious nature of the exploitation of criminal victims that some media engage in. And what I'm wondering is, would you be I know it wouldn't satisfy you, but as an interim step, what if we shielded the photographs and recordings and then sent, this year, right now, and then sent the matter to the FOIA Council to study the rest of it? In other words, so that you wouldn't see photos of these horrific acts on whatever internet or whatever TV, but that the rest of the records would be available to people for
Yeah, I understand what you're asking.
journalists.
So I would say that certainly the worst part of this, photos, videos, diagrams, pictures that show where the body is, I do think that, let's just take a typical sexual assault case that is settled by a plea agreement, in part because by agreement with the victim and the prosecutor, there's aspects of what happened that they don't want in public. It's not a picture. It's just going through step by step, and the questions that are asked by police and prosecutors, in part to prepare them for cross-examination that they know is coming. And there's a lot of information in that file beyond what is pictures and photos. Now, it's a bicameral process. I mean, I will take what I can get. But certainly I do think that there's a pretty fundamental question about whether we think those records should be part of the public discourse. And if we don't, we got to do something. If we do, then that's a decision that the body has and can make.
Thank you.
Mr. Chairman.
Yes, Senator Bell.
I know that we may be on some sensitive territory, and this is a bit graphic, but I would ask Delegate Bell to please, so we make sure we understand what we're talking about, what are the types of questions or information that you're talking about of victims that would be disclosed?
All of it. I mean, a good prosecutor or police record will have every question you think a defense attorney might ask and the answers so that you are prepared to respond to it as best you can, even the ones that you've got objections to, even the ones you think the judge will say, that's not proper evidence. And so the files you have lengthy interviews with people and you ask them about everything. You ask them about their family. You ask them about why their brother-in-law is mad at them. You ask them about the neighbors. You ask about their background and how much did they have to drink that night, all of those things, some of which are going to be evidence at trial. And the rest is just doing your job to make sure that if there is some surprise, you know it ahead of time. Now, going forward, I suppose you might have people not even put it in the file. You'll ask the questions but not write it down. That's a terrible approach. That's certainly not ideal. But again, I think that, and it's been a while, it's been 20 years since I was a prosecutor, but certainly our files, the big ones, had lots of stuff in it. And yes, the photos are the worst. I mean, I think that the photos and just not having the face or the body in it is helpful, but that's nowhere near all the bad photos that you just don't want floating around. But there are other things in these files that I think most people would say, gosh, heck with it. I decline to testify if I know that in 12 months' time, my entire statement, file, everything I say, video in many cases will be, or if we take that out, will be available to everybody in my community to read about. It's actually hard for me to visualize how you would do your job properly if you knew that this was all going to be public, which is what it now is. And in some ways, the journalists are not the cutting edge. The next edge is going to be all of the people who start putting this up on Facebook. And they hear that something happened, and they get the whole file, and they put the whole thing just page by page by page on Facebook for everybody to see. I think it'll have a chilling effect. I hope I'm wrong. And I'm not trying to stall. And Senator, if you wanted to go to another bill that doesn't have people online, I would.
Yeah, why don't we pass this by
Yes, sir.
temporarily?
Thank you.
Since we can't get
This is hard.
testimony in there at this particular time. So, all right. Next is Delegate Shin. So.
Anyway, I really could use a step stool here, but.
All right, Delegate Shin.
Good afternoon, Chairman Barker, members of the committee. Are we taking up 1063 first? Great. So HB 1063 is a bill that seeks to ensure the protections that are established in the Virginia Human Rights Act and elsewhere in our code are extended to cover articles of faith by defining religion to include any outward expression of religious faith, including adherence to grooming practices or religious dressing, and the carrying or display of religious items or symbols. We're making sure that those protections aren't falling short. HB 1063 would make sure that a person seeking to buy a house or rent a home or find employment, they couldn't be discriminated against because they were wearing a cross around their neck or a yarmulke or a headscarf. In the last few years, I think the Commonwealth has demonstrated our commitment to anti-discrimination policies and prioritizing making this Commonwealth much more inclusive and welcoming for everyone. And HB 1063 just further extends those protections to ensure that articles of faith and outward expressions of religion are included under those protections.
All right, are there any questions of the patron? All right, is there anybody who wishes to testify on this issue here?
Thank you, Mr. Chairman. Brian Moorfield from Housing Opportunities Made Equal. We're a fair housing organization. We support the bill because it will help protect housing consumers from religious discrimination. Thank you.
All right.
Mr. Chairman, Josh Hetzer on behalf of the Family Foundation. We also support the bill. Thanks.
Thank you. Anybody else to testify?
If you're in the Zoom room and wish to speak in regards to this bill, please raise your hand electronically now. Mr. Chairman, there are no speakers.
All right, we got a motion to report.
Mr. Chairman, is this your first bill with the Senate?
It is
General
not.
laws. Okay.
It is in general laws. It is in general laws, but A for effort, Senator Bell.
All right. The bill is before us. Anybody got a motion?
You have one.
Oh, okay, we have one, okay. All right, we got a motion and a second. All right, motion and a second to report. And all right. All right, well, if there's no further discussion, we'll vote on the board. So. Oh, I think Jill has his thing. She's not here, so.
Ayes 14, no 0.
Ayes 14, no 0. The bill is reported. So.
Thank you, Mr. Chair.
All right. Delegate Les Adams.
Is there not a second bill before?
Oh, you got another one. I didn't
Yeah.
see that. I'm sorry. That will get you, so. Okay. House Bill 1310.
Excellent. Well, thank you, Mr. Chair. And this bill simply directs the Department of General Services, as well as the Virginia Information Technology Agency, to review and revise their procurement procedures to encourage the use of federal purchasing programs that already exist for procurement practices by state agencies. With this legislation, it's just encouraging the usage of all available cost-saving resources to be considered by state agencies to make certain we're being good stewards of taxpayer dollars. By directing these agencies to look through and find purchasing agreements within their procurement procedures, we guarantee that these potential cost-saving measures don't go unexplored. One additional added value of this legislation is that many federal suppliers are currently located here in Virginia. We've got furniture and furnishing suppliers in Vienna and Woodbridge, in Winchester, and so and they may not be actively considered yet for procurement procedures by our state-level agencies, and this would help to encourage that. By adding this language, again, we're just encouraging more local suppliers to participate in the state's procurement process. Thank you, Mr. Chairman.
All right. Are there any questions of the patron? All right. Does anybody wish to speak, present testimony?
If you're in the Zoom room and wish to speak in regards to this bill, please raise your hand electronically now. Mr. Chairman, there are no speakers.
All right. The bill's before us. All right. We got a motion. Yes, it does. So this would be a motion to report and re-refer to finance.
Was there a fiscal impact statement along with this, sir? Or is it just, sorry, I'm not sure what the procedures are in this.
Finance has asked for the bill to come there.
Got it.
If
Okay,
we
great.
report it. If we don't report it, then obviously it doesn't
I
go
see.
there,
Got
so.
it. Thank you.
All right. So there's a motion. Is there a second? All right. Motion and a second to report and re-refer to finance. Any further discussion? All right. Let's vote on the board. All right.
Ayes 12, noes 3.
Thank you, Mr. Chair, members.
The bill is reported and re-referred to finance. So.
Thank you.
All right. Delegate Adams. So.
Thank you, Mr. Chairman, Senators, members of the committee. House Bill 753, as introduced, was the same as a bill that you previously saw, and that was Senator Peake's legislation to amend the Virginia Human Rights Act. Now, the bill that's before you today, however, is a much more limited version than what you first saw. And I think some of the more robust provisions of the introduced bill are no longer before you. For instance, there were measures to limit the power of the Attorney General to remediate under the Human Rights Act. That is not before you. Also, some of the provisions relating to housing are no longer before you. And so this bill, as amended in the House committee that eventually reported on a bipartisan basis, has three proposals under the Human Rights Act. As you know, in the last term of the General Assembly, this legislation was passed, giving broad authority to redress violations for new bases of discrimination, like marital status. And so what this bill does is seek to provide those religious liberty protections to organizations so that they can fulfill their missions. And it does so in very limited ways. And if you were to start sort of at the back of the bill, the first thing it does is it provides a definition for religion to specify that religion includes both practice as well as belief. That is the same definition that is used in the federal law and is explicitly used by the U.S. Employment Opportunity Commission. The next thing it does is it adds preschools to the list of institutions that are already afforded protections under this act. And so where elementary, secondary, higher education is already listed as institutions that propagate faith that shall not be targeted under this act, this would add preschools to that list. And I know of no objection or earlier discussion that intentionally included or excluded preschool. So I would hope that would be met with, would be welcomed by the committee. And then the heart of the bill, I would say the most important language we do have is at the beginning in the construction section under the Human Rights Act. And that is the wording on lines 20 through 23 that says, nothing in this chapter shall prohibit a religious corporation, association, or society, or any nonprofit institution or organization operated, supervised, or controlled by, or in conjunction with a religious organization, association, or society from taking any action as is calculated by it to promote the religious principles for which it is established. When I presented this bill in the House, I mentioned that this language was specifically lifted from similar laws in New York State, but I have since come to learn that there are other similar provisions in other states with related statutes such as these, like New Jersey and Massachusetts. California is even broader, exempting all religious organizations altogether. And so that is the proposal that's before you with this amended bill. And I know that there's several organizations that wish to speak to this, and I think they've been waiting online to do so. There may be some people in the audience as well.
All right, are there any questions of the patron? Yes, Senator Evan.
So specifically, you mentioned preschool. So this would allow a preschool to turn away a child who has two dads or two moms under this, or they would, right now, a preschool that wants to limit its attendance to people of a particular faith can do so. But once they open it up, they can't discriminate. But this would allow them to discriminate against children of gay parents or of people of color, or if they chose to, the way the bill is constructed, no?
Senator Eben, with respect, I would say no. I think that the only inclusion for preschool here is in the listing that is already provided for the other educational institutions. Specifically, it's section 2.2-3905 of the code under subsection I believe it's C2. And the way the law already reads is that for an elementary, secondary school, or institution of higher education to hire and employ employees of a particular religion, if such elementary or secondary or institution of higher education is in whole or in substantial part owned, supported, controlled, or managed by a particular religion. So this is in the exemption statute under the employment section. And so under that scenario, we're saying also allow preschools to have that decision-making in terms of when they're a religious organization, a religious preschool, early learning center, that they can also, like elementary schools and secondary schools, employ people who are consistent and who hold to the same faith doctrines that they propagate.
Thank you.
All right, are there other questions? Yes, Delegate Mason.
Mr. Chairman.
Chairman, Senator.
Bonnie.
Right.
Thank you, Mr. Chairman. So it seems the key to the new language is will not prohibit them from taking any action as is calculated by it to promote the religious principles for which it is established or maintained. And we had a robust hearing on the other bill, and hiring was the main focus. Could you give us just your take on what actions you could envision being covered by that language?
Thank you, Senator, for the question. And the first way I would answer that is to say, Mr. Chairman, that this provision here is in the construction section. So when you look at the language directly above that, it indicates that the provisions of this chapter shall be construed liberally for the accomplishment of his policies. And then it goes on to list some of the new areas in the law that previously did not exist as a basis for redress. And so what we would like to do is to say this legislation that's being proposed, we want to make it clear. And in truth, you know, it's our position that this would sustain constitutional scrutiny already, that this is a reflection of what we think is First Amendment law and protections that already exist. And so we're saying when you construe this chapter, this is not to go after a church or a Christian school or, and as proposed, a preschool. And to say, no, for instance, the Attorney General has remedial powers where he could come on to a civil suit that was filed by a private individual, or where there may be some sort of affirmative action to correct what are perceived as discriminatory practices, that these institutions ought to be able to both act out their faith, hire people who are consistent with their beliefs, and we would like to make sure that that's certain, so that this law, this newly enacted law, can never be used as a vehicle to interfere with those actions.
Mr. Chairman?
Yes, Senator Hashmi.
Thank you, Mr. Chairman, and thank you, Delegate. You know, when we heard the Senate cognate of this bill a few weeks ago, the patron at that point said that the whole point, and this has been quoted in the press frequently, that the whole point of the religious exemption bill was to legalize discrimination against LGBTQ plus people. Do you agree with that statement?
Senator, Mr. Chairman, I would say that that's the way I think that opponents of the legislation would frame this proposal, and I would not agree with that framing of it. I think what we're just saying is allow religious organizations to operate freely under our heritage of religious freedom as they always have. And under this new law that we have, there are specific protections for communities such as that, and we're just saying that your freedom of religion and your right to practice your faith and associate and have organizations that hold certain doctrines that may not be that may be disagreed with by others is not something that would that the state should be vested with the power to interfere with. That's the way I would address this, as certainly the reason I propose this legislation.
All right. I have a question for you. Can you name anything that lines 20 through 23 would prohibit them from doing? It says nothing in this chapter, and it goes on to say, from taking any action as is calculated by it, not by someone else, to promote the religious principles for which it's established. And it seems to me that that is as open-ended as you almost can possibly get. And so therefore, anything that a religious organization would do would be acceptable.
Well, Mr. Chairman, I guess you're saying is that too broad? Is the suggestion that
that's my interpretation is that this is basically unlimited. Its breadth is infinite.
Well, I think it would be similar to, as I say, the way it's reflected in other provisions in the law in other states, in that there must be. a case would always be fact determinative. And if something is so outrageous as to not reasonably be calculated as part of, the faith principles that are already protected,
but
I don't think I don't know what type of action may be speculated about, but we know what type of action we think that people ought to be able to do.
All right. All right. Are there any other questions of the patron? All right. Are there people to speak on this bill? We'll start out with those in favor of the bill.
Mr. Chairman, members of the committee, Jeff Caruso with the Virginia Catholic Conference. This bill recognizes there are diverse religious beliefs and allows people to practice them. It provides space for conscience. Non-discrimination laws and provisions that provide space for conscience can coexist. In fact, they do coexist in many states. The key language in this bill, lines 20 to 23, is from the non-discrimination laws in New York and Massachusetts. The clarification regarding the term religion in lines 179 and 180 is the definition of religion in the Federal Civil Rights Act. These are extremely modest but very important clarifications. They ensure that religious employers can make decisions according to their religious beliefs. They are well aligned with what other states do. We urge you to adopt them here in Virginia. Thank you for your consideration.
All right, thank you.
Could I ask Mr. Caruso a question?
Sure.
Thank you, Mr. Chairman. The Virginia Values Act has been law for 19 months, and I was just wondering if you could detail any problems that you've had with it, because I thought the faith organizations have been coexisting during that time without any major problem. Has there been a difficulty, a particular that you could cite?
We're not aware of any actions up until now. There certainly have been actions in other states where these types of non-discrimination laws exist, and we think it would be prudent to add these laws these provisions as many other states, including New York and Massachusetts, have done.
Thank you.
Mr. Chairman, Josh Setzer on behalf of the Family Foundation. We support the bill. We think it just really maintains the status quo of the rights that religious organizations have always had in Virginia and what we believe the Constitution permits. So thank you.
Thank you. Is there anyone to speak in opposition to the bill? Okay, go ahead.
Good afternoon, committee members. Speaking in support of the bill, actually not in opposition. I think a lot of the remember Senator Hashmi had asked previously when the Senate bill was proposed if any other faith members besides Christians would come up to speak in support of SB 177, and I had gone up because I'm not a Christian, I'm a Muslim. But I do feel that the business of religion, matters of religion, is a personal issue, and a religious institution should be free to practice or express their religious principles without interference from the government. So the only reason why, and the main reason why I do support this bill, is because the fact that government should not interfere with how religious institutions organize themselves, who they hire, who they do not want to hire. It's up to the matter of the religion. As sensitive issue as a religion is, it's matters that we should not allow people who are not, people who adopt that faith should not be dictating as to how somebody else should be practicing their faith. So therefore, I do strongly wish, and I do request that members of the committee go ahead and put their support behind the bill. Thank you.
Thank you.
Mr. Chairman?
Yes.
If I could just ask the gentleman, are you speaking on behalf of any Muslim organizations, or are you speaking as a private citizen?
As a private citizen, as well as other Muslims who have also expressed their concerns about the current situation as is.
But no direct organization, is that correct?
Not that I'm aware of, no.
Thank you.
All right, come forward. Yeah.
Yeah, good evening, Mr. Chairman and members of the committee. Narissa Rahaman, Executive Director of Equality Virginia. I am here to speak in strong opposition to House Bill 753, which would create broad religious exemptions and undermine the Virginia Values Act, which, as Senator Eben has pointed out, has been law for 19 months. And in those 19 months, I have not heard of one church or religious affiliated organization or educational institution that has had to close its door. Religious freedom is a core American value, and it is important. But religious freedom is not a license to discriminate against LGBTQ people, minorities, and other marginalized communities. So I do ask you to oppose this bill.
All right. Anyone else wish to speak?
If you're in the Zoom room and wish to speak in regards to this bill, please raise your hand electronically now. Mr. Chairman, we have multiple speakers, starting with Vic Nichols.
Okay.
Good morning. Why is someone else's religious beliefs and practices a problem to other? The only purpose in doing so is to stop religious practices that a person or group doesn't like. I am a Christian. I don't go to Muslim mosques to get hired because we don't believe the same, and I'm not going to force my beliefs on them. We don't need another masterpiece cake issue where people who simply don't like someone else's beliefs decides to come in and get rid of them. It works both ways. If you want Christians to keep their stuff separate and keep God out of schools, then you need to keep your God out of our schools. Thank you.
All right. Next.
Jeremy Woody, please unmute and begin your testimony.
Thank you, Mr. Chairman and committee. I am here on behalf of Ridgeview Christian School, the parents, students, and staff, as well as a part of the Association of Christian Schools International, the largest Protestant association of Christian schools in the U.S. We have 85 member schools here in the Commonwealth that are represented, and have just a few thoughts for you. And first of all is the fact that as the head of school of a private school, I have families who choose to come our direction for different reasons. And the primary reason is because of our faith and the tenets of our faith and living out those tenets. And we believe we should have the right to ensure that those who we hire follow those, because those who are our staff are leaders. And we see them as leaders and want to make sure that they continue to live out the principles that we hold to. My understanding from many others is that this is wording that has precedent from New York and other states. And I know that questions have come up about the wording about nothing in the Human Rights Act should prohibit these associations from taking any action to promote religious principles. I think the thing to understand is the thing that defines us the most is who we hire as leaders and how we hold them accountable. And that's not just on what they believe, but how they live it out. Again, it's something that Christian schools like myself are put very upfront in terms of people who are coming to interview with us. We were very clear on who we are and what is expected, and want to just continue to have those same opportunities.
All right, thank you.
In the Senate. Yes, sir. In the 2 weeks ago in the Senate committee, or a couple of weeks ago in the Senate version of this, one of the public comment against this bill said that the freedom of religion should not give you the right to be able to push your beliefs onto others. However, as it stands, the door is open for that to actually happen to religious organizations by not protecting these hiring practices. Thank you for your time.
All right, next speaker.
George Trifaites, please unmute and begin your testimony. George Trifaites, you are muted. Please unmute.
Thank you. Mr. Chairman and members of the committee, my name is George Trifaites. I serve as Director of Government Affairs for the Association of Christian Schools International, ACSI. We are the largest Protestant school association and wanted to express again our support for HB 753 to provide clear and unambiguous religious protections so religious schools and ministries and tens of thousands of families who choose them can continue to live out their faith. I might point out with respect that we don't consider it discrimination for Christian institutions to require Christian employees to live by Christian doctrinal standards, including the doctrines related to Christian marriage. So also, please bear in mind that 78% of parents who choose private schools choose religious schools, and there's no doubt that our vision of human dignity plays a key role in those decisions. And so I would urge you please to support HB 753, and thank you for your consideration.
Thank you. All right. The bill is before us now. Does anyone want to make a motion?
Move to reform.
Second.
All right. All right, substitute.
Second.
All right, the primary motion is to report, and the substitute motion is to pass by indefinitely. So we will vote first on the substitute motion, and if that fails, then it will go back to the primary motion. All right, if there's no further comments, we'll vote on the board.
Ayes 8, noes 7.
Ayes 8, no 7. The bill is passed by indefinitely.
Thank you, Mr. Chairman.
Do you have
Members.
any other bills?
No, Mr. Chairman.
Okay,
That was-
all right,
Thank you.
thank you.
We go back to
All right.
delegate bells now, I think, since the Zoom's back
Do
up.
we have that? Okay. We will return to Delegate Bell's bill. And do you want to get the people who are on the Zoom?
Chair, I think
If you are in the Zoom room and wish to speak in regards to Delegate Bell's bill, please raise your hand electronically now. Mr. and Mr. Harrington, you will be first.
Hello.
Yes.
Good afternoon, Chairman Baker and members of the committee. I'm Jill Harrington. I'm Morgan's mom and president of Help Save the Next Girl. This is my husband.
Hi, I'm Dan Harrington, and I'm a physician and the vice dean at the Virginia Tech Carilion School of Medicine. Our daughter Morgan was a 20-year-old sophomore at Virginia Tech when she was abducted, raped, and murdered in 2009 after a concert in Charlottesville. Morgan's remains were discovered thrown like refuse in a field in Albemarle County. You never get over the death of a child. You can get past it, but the pain is ever present. We have spent the last 12 years working determinedly to serve our community and create positive legacy for Morgan. 3 things that we've done that have been significant in defining Morgan's short life. We've developed a scholarship at the Virginia Tech Carilion School of Medicine to train medical students and return healers to the community in response to our injury. We have also started a school in Zambia, Africa. Morgan was to be a teacher, and the school in Africa is going to be able to train far more students than Morgan ever would probably in her life. We've also developed Help Save the Next Girl. It works to educate and protect young people and support victims' families. We want this service to define Morgan's short life, not the gruesome details of her murder. This work was provided a measure of comfort and wholeness, but ours is a fragile equilibrium that will be disrupted by open access to investigative records in Morgan's homicide case.
We believe in media access. The media has been invaluable. First, they helped us find our daughter. Then they helped us find her killer. After his arrest and conviction, we continue to work with media to save lives, educate young people, and keep them alert to the prevalence of predatory danger. We also try to provide a template of hope to other families that have had grievous loss, to know that survival and wholeness is possible given time. I believe that the public's right to information must be balanced with the family's right to privacy. For example, I'm concerned that free access to information would energize the murder groupies, folks who are titillated by violent acts, particularly against young women. We received a number of disturbing fictional pornographic descriptions of Morgan's final moments. Unlimited access to case material is likely to reignite that deviance. It would be incredibly painful to endure once again. We ask for your compassion. Please spare us and other victims' families the anguish of reliving the details of our beloved's murder again and again and again. We hope that you will support House Bill 734 and protect the privacy of victims' families. We have suffered enough.
Our friends in law enforcement tell us that to comply with the open FOIA access requests in Virginia would be ruinous to their already strained resources and budgets. As leaders, we hope you will act as prudent stewards of resources in the Commonwealth and support House Bill 734. Jill and I appreciate this opportunity to speak and share our concerns with you. We also thank Delegate Bell for crafting this House bill, which will protect victims' families from additional and unnecessary pain. Thank you for letting us speak.
Thank you very much.
Matthew Harden, please unmute and begin your testimony.
Good afternoon, Mr. Chairman and members of the committee. My name is Matthew Harden. I'm a former Commonwealth's attorney for Greene County, and I'm also one of the very few private practitioners who practice almost exclusively in the realm of the Freedom of Information Act. I think that this bill has the very best of intentions. I think that it's going to have some very problematic results, and I think that that's unfortunate. I don't think that there's anybody here today who thinks that Delegate Bell proposed this bill for anything other than the most wholesome of reasons, protecting families. And I think that the Harrington family and the Graham family is going to speak later. They both deserve our respect and our sympathy. I think that this bill, however, is going to have some very detrimental side effects. And I think that it's worth reminding ourselves why this bill was passed. This bill includes exemptions for things like photographs that have already been discussed today, but it also has an exemption for personal privacy. And I can tell you that in cases that I work on, I see the personal privacy exemption invoked over and over and over again, and it is used to withhold vast parts of the police file. These exemptions are actually modeled after provisions of the federal Freedom of Information Act. We don't see a problem, for example, that the FBI receives FOIA requests. They withhold things that need to be withheld, and they produce things that need to be produced. They don't have a problem. And all that this bill did last year is bring us in line with the federal act. The personal privacy exemption, for example, is modeled almost verbatim on federal law, and we see often that the recipients of FOIA requests cite federal Supreme Court cases involving that exemption to withhold records. So when folks say they're scared about deeply personal information being public, I think everybody's scared of that. I think that that's exactly why the feds passed their law and why the Virginia agencies are citing federal law, federal precedents, and the nearly identical Virginia law to withhold invasive personal information. But what this bill is going to do is it's going to create a problem because you have closed investigations, for example, where family members disagree. The families in Virginia Beach, for example, sought information. The Graham and Harrington families prefer that information not get out. And I think that that's an understandable dynamic, that families sometimes disagree. But the solution isn't to impose a one-size-fits-all solution on the rest of Virginia. And I think that really this is, again, the bill is a solution in search of a problem. But we also have other angles here. We have a definition of immediate family in the bill that is really referring to nuclear families.
Can you try to wrap it up? We got several other speakers, so. Yeah.
Recognized as immediate family under this bill because of that definition. Folks who want police accountability, clients that I help get convictions overturned, but not under habeas or under the writ of actual innocence, I can't help them if this bill is passed. So for further study as opposed to passing it, I think the FOIA Council can weigh in again, and I think the Judiciary Committee can also weigh in. They know that this bill is going to create a new cause of action, a new injunction procedure. This needs some more study. It's a good idea, but it's going to have some bad side effects. Thank you for your time.
Thank you.
Susan Graham, please unmute and begin your testimony.
Thank you. Mr. Chairman, members of the committee, thank you for allowing me to speak. My name is Susan Graham, and I'm the mother of Hannah Graham, the 18-year-old University of Virginia student who was abducted and murdered in September 2014. Excuse me. I'm speaking in support of House Bill 734, as I believe that the changes it would introduce will save me, my family, and other victims and their loved ones from being re-victimized as a result of the broad public dissemination of criminal investigative files. Firstly, I should make it clear that I'm non-partisan and I fully support freedom of information and government transparency. I recognise the importance of ensuring that those with a legitimate interest in a case can access relevant information about it. However, certain amendments made to Virginia's Freedom of Information Act in July last year have resulted in unintended consequences which adversely impact victims of violent crime and their families. My husband and I first became aware of the Freedom of Information Act changes last November when we learned that a request had been made by an international media company for access to the Albemarle County police files relating to the horrific crimes committed against Hannah. Since Hannah was so brutally taken from us, we have received and declined numerous requests to contribute to programs about what happened to her. The Freedom of Information Act request to Albemarle County Police Department was made shortly after we had rejected one such very persistent approach. And in recent weeks even, we have received several similar requests from a different company. I struggle to come to terms with what happened to Hannah. No one ever gets over the loss of their child. And what happened to Hannah is every parent's worst nightmare, and it's a nightmare that will never end. It is a source of considerable additional stress to me that third parties now have the right to obtain and broadcast details from the closed police files, all in the name of entertainment. Surely such access to such information should be restricted to those with a legitimate interest. That is why I'm speaking in support of this bill. Under the bill, victims and their loved ones would have access to information about a case, as would those pleading their innocence after conviction. However, broad public dissemination of police files would not be required. This bill closes a loophole, and I hope it is something that legislators on both sides of the aisle can support. Previous speakers have referred to certain exemptions contained in the existing Act. However, no consideration can currently be given to the mental or emotional distress that disclosure would cause the victim or their loved ones. This bill addresses that omission. The sentiments behind the changes introduced last July are admirable. Please do not allow them to be used to facilitate voyeurism at the expense of the mental and emotional well-being of victims of violent crime and their loved ones. Haven't we all suffered enough? Thank you for listening.
Thank you.
Ariana Zohigi, please unmute and begin your testimony.
Hi, my name is Ariana Zogi. I'm a post-conviction attorney here in Virginia, and I just wanted to express some concern about the way this bill is written. I think it allows attorneys to access information, but it doesn't allow them to use that. Part D of this bill explicitly says that attorneys are not allowed to release investigative files to anyone except their own agent. So that means, they couldn't present it in court if they found evidence of innocence. They couldn't present it to the governor and to try to argue for clemency. Last year in Norfolk, Innocence Project attorneys found evidence in Messiah Johnson's case that there had been a suggestive lineup used and that had been concealed from the defense. And they were able to get that document into the hands of the governor, and he was able to grant clemency to Messiah Johnson, who, seems to have been innocent, and he was able to get out because of that. And under this bill, the attorneys could have seen that lineup existed, but they couldn't have given it to the governor to try to argue for clemency. So I would just ask that if it is the body's intention to pass this bill, that be amended so that the attorneys are able to use the information in a way that's productive. And I understand Delegate Bell to be saying that the attorneys are not the problem. So I would just ask that, they be allowed to use the information as they see fit.
All right, thank you. All right, we've heard the testimony on both sides of the issue. The bill is before us. Is there any discussion or anyone want to make a motion?
Mr. Chairman.
Yes, Senator McPike.
I'd be interested in the delegate's response to the last comment for subsection D in that regards before any motions are made.
Mr. Chair, citizen, I don't do that kind of work. And so I believe I accept what she is saying is true, that if you can find it, the whole point is to let them review it lawyers, well, we get disbarred. I mean, we are constantly in receipt and use information that is under seal and not available to the public, and if to be released, it would cost us our bar license as well as make us subject to civil penalties. So it's not perfect, and people can see it on the desk, and somebody can walk out with it, or it can end up in the trash and somehow enter the bloodstream. But that is not what the you've heard them. I mean, now they've testified. That's not what they're worried about. They're worried about. So what I'm getting is, I certainly would not object to that. I'm not sure that, since I don't do that kind of work, I'm the smart, right person to craft how they could use it, but still have protections against subsequent, misuse or release or something. But I would not object to that.
Mr. Chairman.
Yes, Senator
So,
Mason.
Delegate Bell, in special session, we heard from a family who begged us to open the files. We couldn't get there. Then in regular, same gentleman from Virginia Beach, I deserve the right to hear these things. That's how we got here. Now the families are saying exactly opposite. All right, and you hear from the professionals talking about the use of the material for innocence of others, or, one question, Ms. Graham talked about some horrible requests. Have any requests had to be turned over at this point from those cases?
I would say that this all started when Albemarle Police got the FOIA request. They are in the process of, complying, if that's what you're asking.
But to this point, they've not had to turn over anything. Excuse me.
I don't want to, I know they have received the request and are in the process of answering, and I feel uncomfortable. I don't know where they're at or how hard they're fighting or what they've turned over, but I know that's what's driving this.
So, Mr. Chairman,
yes.
You see where we're going. We wanted to help the first family. We absolutely want to help the next families, but at the same time, not tying up some of the open process that we put on paper. You don't like to write things on the fly, and this is way beyond my ability to gauge the legal ramifications of it. How can we get to where you want without rolling back some of the other legal elements? Maybe it's not here tonight, but how do we get to that point and be able to help the families just like we wanted to help the last families open them up?
Mr. Chair.
Yes, Senator.
I'd say to the gentleman that we collectively, and I'm aware I didn't vote for it. I'm aware that I'm not trying to replay the fight from last year. What I'm saying is this is not a repeal of that. This is an amendment. And I would suggest that last year it did a number of good things that the victims then had access to. It did some other things that may or may not have been intended, so I'm not getting into an argument about intended or but these are consequences. And if that got us, what is that thing where everything makes it 90% better? So the first year you get 90%, next to 99, next to 99.9. I would suggest that, as they say, to not do something is to do something. And so if we send this off for a year, you're making a decision to let it rely as it is for this year. The alternative is to do something and then study it. Mr. Chair, a number of ideas have been proposed to which I don't object. If the committee is headed in that direction, and it is the will of the committee and your will to put this off to your next meeting, I don't like writing things on the fly either, especially not a body of law that I'm familiar with, and that might be in a position. Now, on the House, occasionally we do something taking a temperature, which would just be if there, in fact, is not much interest in a bill. It is almost cruel to send a member off to do a lot of work and then come back and, it dies 11-5. If this is something, though, that has any chance of success, I'm happy to keep working on it with any member who is interested. Now, some of the interests might just be they can't. It's reconciling different goals. But, Mr. Chair, I'm at the will of the committee. You've taken a lot of time on this.
Certainly. And we're trying to make sure that something as significant as this gets a full airing here. If anyone wants to make a motion to pass it by for the day. And
so moved, Mr. Chairman.
All right. There's a motion to pass it by for the day, and we'll take it up again next week. If that's the case, all in favor say aye. Aye. All opposed
Thank you.
say no. Oh,
Thank you,
okay.
Mr. Chair.
Thank you. All right. Thank you. Okay. Oh, okay. All right. Delegate Freitas, you.
Thank you very much, Mr. Chairman. Essentially what HB 307 does, the problem that we're trying to address is when people submit for a FOIA request, oftentimes for the first time, they get hit with a bunch of fees that they didn't even know it existed. Sometimes they end up having to pay those fees even if they would have made a different decision if they'd known what they were going to be. So what this bill did is we tried to solve a couple of different issues. One is we changed the law to say that when you do a FOIA request, the person that is responding to that FOIA request needs to let them know that there might be associated costs with conducting that. Then they can offer them an estimate. So they can say that if you would like to know roughly based off of your search criteria or whatnot, it would cost this much. Then what they can do is they can charge for the estimate, which would obviously be a much lower cost. And then if they choose to go forward with the FOIA request, whatever they paid for the estimate would then be rolled into the total cost of what it required to do that. The only other thing that we added in the language was to say that basically bodies need to take all reasonable measures in order to make sure that the costs are as low as possible. That's what the bill does, and I believe there was an amendment offered by Senator Dunham.
Mr. Chairman, that should be posted online.
And to just speak briefly to that amendment, she was, I believe the senator was attempting to do two things in that realm. One was to make sure that when, parents aren't getting hit with, excessive fines when they're making requests with respect to the schools. And then on top of that, the other concern is that there is a code section which specifically deals with requesting certain medical records. And so we didn't want to do anything in this that was going to adversely affect the law that already, and that's my understanding of what the amendments were, but I'd certainly be open if council has a much better and more accurate explanation.
No, I think that that is a good explanation, but I'm not currently sure if scholastic records, how broad that is. So if we want to do like amendments later, that's fine. But.
And I'd be happy to take any questions from the committee. I had 30 people lined up to support it, but I told them don't bother.
All right, we have an amendment that's proposed here. Anyone want to make a motion to adopt the amendment?
So moved. Second.
All right, we got a motion and a second to adopt the amendment. All in favor say aye.
Aye.
All opposed no. Okay, the amendment is part of the bill now. Are there any questions anyone has of the patron? All right. Is anyone wish to speak to this issue? So.
Thank you, Mr. Chairman. Megan Ryan with the Coalition for Open Government. I really appreciate that we're having this discussion about fees. This is something that we did try to talk about in the FOIA Council over the past summer. We didn't actually get very far for a number of different reasons, including just a truncated process. But the amendments raised some interesting questions. The current language raised some questions about what this does to the tolling of the response time while this estimate is being requested. And so I don't have any opposition to the bill, but I just think it's a perfect opportunity for us to actually sit down some more and figure out how to rein in costs and also make it workable for governments to impose them. So we would ask that this bill go to the FOIA Council.
All right.
If you're in the Zoom room and wish to speak in regards to this bill, please raise your hand electronically now. Mr. Chairman, Vic Nichols would like to speak.
Yes, thank you. I have been in the position where governments have used FOIA costs to either stymie things or stop things all completely, and this would help take care of a number of those issues. Please move to report. Thank you.
All right, thank you. Anyone else wish to speak here? All right, the bill is before us. Does anyone want to make a motion?
Mr. Chairman, I just want to speak to this.
Certainly. Certainly.
I apologize for missing earlier after waiting all this time. I really was calling on a patient. But, there are families that have reached out that have been trying to sort things out for their children after COVID, that have, IEPs and specific requirements, and they have been charged as much as $30,000. They already pay taxes in a locality for the education. I really hope it'll be the will of this committee to move this forward today. This is quite reasonable. It's actually a lot of the crafting of the bill has been done in conjunction with leadership from the FOIA Council. And so this is just really something that does not need to wait a year. And I hope that it'll be the pleasure of this committee to move this forward this year because, we need to have access to transparency, and you can't have that if it's so expensive that you can't afford it.
Mr. Chairman.
Mr. Chair. Oh,
All
sorry.
right,
Go ahead.
I'll defer to Jill. She's senior to me.
No. Whatever you're going to say, don't say it. She's whatever. I was just going to say, Mr. Chair, I feel really strongly that we should move this bill forward. I feel like there are so many families who both want and need, for a variety of reasons, information. And you shouldn't be deprived of that information simply because you cannot afford it. And that's fundamentally what's happening here. And so when families reach out to me to work with school issues that they have, maybe it's a child with special needs and they have all these concerns and questions and they're trying to get information, the last thing you need is someone to come along and tell you that it's now prohibitive because we're charging you too much. And to Siobhan's point, they're already paying taxes. And so I would hope that the members of this committee would see this as a practical solution to something that we owe families anyway. So thank you, Mr. Chair.
All right, any other discussion? Senator Stewart, do you want to weigh in?
I move to report the bill as amended.
All right, there's a motion and a second to report the bill. If there's no further discussion, we'll vote on the board, so.
Ayes 15, no 0.
Is this what you guys feel like all the time? Thank you very much, Mr. Chairman.
Congratulations. Elections of consequence. All right. Next we have.
Mr. Chairman, haven't voted on the prevailing side. No, just kidding.
Delegate Leftwich to be followed by Delegate Head. So.
Good evening, Mr. Chairman and members of the committee. Which one would you like to hear first?
Your choice.
Let's take the easy one first. That's House Bill 1364, real estate settlement agents with the emergency clause. I think Senator Lewis had an identical bill trying to clean it up or add clarification to a letter.
Was this the bill that came in late?
Yes.
Okay. All right.
To clarify a ruling from the Bureau of Insurance.
Right.
Yeah.
All right. Is this identical to Senator Lewis's bill?
I'm sorry. There's a substitute? All right. Clerk tells me
You
there's
have a substitute, I hear.
Move the substitute.
Well, there were little hieroglyphics here, so,
Yeah.
but, so.
I believe there was a substitute requested, and we've posted it online now.
Okay.
Okay. Yeah.
I think it's a substitute because it was drafted by actually Delegate Simon. And with the help of others, yeah, so I called a friend. And because it was blue
Trying
covered.
to get your bill defeated? Is that what you said? So.
Because it was blue covered, Legislative Services had to draft it and submit it, and that's the substitute. So it is identical in verbiage, that's what I understand.
All right.
It's a pretty important bill, Mr. Chairman.
Right.
And I think we all support it. I just would like to.
Yeah, I think the full committee did support Senator Lewis's bill, so.
Mr. Chairman, I think we're having some technical difficulties. I am able to see only half of the bill. So we could read it's a fairly short substitute if you'd like to hear the language. Sure. So we will be adding to section 55.1-1006 a sentence at the end. Nothing in this chapter shall prohibit a seller from retaining an attorney licensed pursuant to Chapter 39 of Title 54.1 to represent his interests and provide legal advice pertaining to escrow, closing, or settlement services, or Romanet 2, selecting a title insurance agency or agent licensed pursuant to Chapter 18 of Title 38.2 to coordinate escrow, closing, or settlement services on his behalf. An attorney or title insurance agency or agent retained or selected by a seller pursuant to the provisions of this section shall not be responsible for the disbursement of any funds, including funds held in an escrow account. Then there's a second enactment that the provisions of this act are declarative of existing law, and a third enactment that an emergency exists.
So I'm being, that's different than what I have. That's not what I understood it was to be. That may have been the original language, but I believe
It's slightly different from the engrossed version of the bill, where the engrossed version of the bill didn't have the two subsections. This one now has two subsections and adds the subsection to selecting a title insurance agency or agent to coordinate escrow, closing, or settlement services. So that would be the portion that was missing from the engrossed version.
perhaps you want to take this by for a moment.
Yeah, we do. We have one more.
Let me go confer with the patron.
All right.
Mr. Chairman, I second. To take it by so we can find out what he's got temporarily.
Yeah.
So I don't think we want to adopt a substitute.
Okay.
We did not, I don't believe.
Right.
No,
I think
we
we
did
want
not.
to plow on with what the House version was, which I believe was identical to Senator Lewis's. Is that correct? Yes. That's what I'm hearing from. Okay. Well.
Yeah, we could conform this to Senator Lewis's if you want.
775.
I think that probably would work the best, because if there's any difference, we can resolve it in conference.
Mr. Chair.
If they're identical, there's no problem.
Right, I would second that motion, and I would just apologize to the patron and to the members of the committee, because there had been a bunch of back and forth between me and legislative services on the bill, and just asking questions and making some inquiries, and I did not realize that they had prepared a substitute for me, so I wouldn't feel comfortable moving ahead with that right now. So at this point, I would prefer we just move ahead as you've just described.
All right, is there a motion to conform Senator Lefkowich's bill to Senator? All right. All right, is there a second? Yeah, we got a second here. So all in favor, say aye.
Aye.
All opposed, no. All right.
Move report. Second.
All right, we got a motion and a second to report. And if there's no further discussion, we'll vote now.
Mr. Chair, my apologies to the
15, no
patron.
0.
Ayes 15, no 0. So,
No, it's not a substitute.
Okay, because that's what it says
Yeah.
up there.
Right, so,
Right,
yes, it is.
right.
Yes, exactly.
Now, I thought that was going to be the easy one, Mr. Chairman, but
All right.
maybe it won't be. Let's hope not. Okay, so the second bill, Mr. Chair, members of the committee, is House Bill 1339. It's a facial recognition technology bill. And my request would be that this body adopt the House version. And the reason why I say that is because the House version has more guardrails. There were several floor amendments that were proposed on the floor that were adopted that in large part, or perhaps in totality, came from talking to members of the opposite side of the aisle, in particular the Black Caucus. So I'm going to go over real briefly what those amendments are. The first, the most important, well, I'll go over four of them. One of them was more technical in nature, but the first one is that part of the data that is supposed to be collected is demographic data on cultural subgroups. And then and along with that collection of that data, that will be part of the data that the Crime Commission will scrutinize when they prepare their report and give that to the General Assembly. And then the amendment also included a penalty for anyone who misuses the software. The first penalty would result in admonition and training, and the second one would result in a Class 3 misdemeanor and termination of employment. And then the last amendment, members of the committee would put a sunset on the bill, which would expire on July 1st of 2026. And what that's intended to do is give time to do the report, let people digest it, and then if what we see we don't like, the bill expires. If we like it, we keep it. If it needs modification, we have time to modify it before and during the 2026 session. So
All right.
That's pretty much it in a nutshell. Happy to answer any questions you have.
All right. Are there any questions of the patrons?
Mr. Chairman.
Yes.
Thank you for the patrons for picking up the House amendments. That was one of my concerns, was we voted on the Senate amendment with some of the guardrails, so I appreciate you adding those.
All right. Senator Stewart.
Thank you, Mr. Chairman. And I apologize, I was trying to go through this fast, Jay, and I think I saw where you couldn't use information gathered as a result of this for probable cause for an arrest. Is that what it said? Because now I can't find it. Yes.
That's correct.
A match made through facial recognition technology shall not constitute probable cause for an arrest, but shall be admissible as exculpatory evidence. And I supported Senator Serval's bill kind of reluctantly because this stuff scares me. But something that was important to me was that you not be able to use this on an affidavit for an arrest warrant or for a search warrant. Does that bother you to amend it in such a way as that? Because as I read this now, I think you probably still could. Or do you think yours is broader?
So here are my thoughts on that, Senator. The first is, I think, more strategic. And the idea, I think, is that we want to get something on the governor's desk that he'll sign. And if mine can leave the General Assembly without amendments, clean, rather than having to go back to the House and for approval, then we can get something there. I believe there will be an attempt to make some amendments to Senator Serval's on the House side. We can address that. I would commit to you that I would address that on that side. And then if that bill can be amended over there, gets through the House side and is accepted by the Senate, then his bill would take precedent because it would be the last one signed. So now that's the first thing I'd say. The second thing is that I don't believe that the way I interpret the bill is that this facial recognition could not be used for probable cause to arrest. So I wouldn't think that you could put that on affidavit. You're not allowed to use it. Now, as far as a search warrant, I might have to phone a friend on that. My instinct tells me you probably could use it on a search warrant.
And, Mr. Chairman?
Yes, Senator Stewart.
My concern is that this, look, I get the fact that you can do this already, but it's slow, and this speeds it up for you a great deal, but you're going to have a fair amount of false hits where you think it's somebody, and it really isn't. And that's just the reality of it, but I think it is an important tool for law enforcement in certain cases. Really concerns me to think that we could list something on an affidavit for either a warrant of arrest or a search warrant. That's kind of a deal killer for me. And you may not need my vote. I don't want to harm your bill, but it's just really important to me.
Well, again, and perhaps I can get some, I don't know if any of the folks can help me on this, but I wouldn't think that you can use that on an arrest warrant, because you cannot use it for probable cause to arrest. That's my interpretation of it.
Do you, Mr. Chairman?
Yes, Senator Stewart.
Do you object to us in amending it with the language that I amended Senator Serval's bill with? And it said something to the effect of, and somebody smart down there at the table may have it, that it can't be used on the affidavit for either the warrant of arrest or search warrant. It was something simple.
I personally do not object, because I think that's not a bad direction to go. But let me, if I could, just speak with the folks who brought this to me, because again, the idea is we want to get something.
He's nodding okay.
Yeah, that's okay.
He's nodding okay.
Yeah.
All right, I would move that amendment, and that's consistent with what we did before, and I think it's a pretty important safeguard.
All right, we have a motion and a second to add the prohibition of using this for a search warrant.
Or affidavit for search warrant or arrest warrant.
All right, well, I thought it was already covered with the arrest warrant, but we could cover it twice.
No harm in being certain.
That's right, okay. All right, motion and a second to basically say you can't use the facial recognition on either a search warrant or an arrest warrant. All in favor say aye. Aye. All opposed, no. All right, that amendment is adopted.
Mr. Chairman?
Yes, Senator Hashmi.
Just a question for the patron. I've seen the demonstration of the technology. It's incredibly impressive, and it's rather intimidating to know that we have this capability. I'm just curious, how I just saw one vendor's demonstration. Do we know how many different vendors there are for this technology, and how many would be considered by the Commonwealth in terms of deployment, or would we select one vendor and then have it deployed uniformly across the Commonwealth?
Okay, so I'll take a stab at that, but if someone here, if I get it wrong, I would expect someone behind me to correct me. I believe there are
He's
four or
already
five,
coming, so.
5 to 6.
Okay.
5 to 6. 5 to 6 vendors that have this technology. Is my understanding under the bill that any vendor could be chosen that meets the standards set out in the bill for local law enforcement to be able to utilize. So you would probably have an approved list of vendors that meet those standards, and then local law enforcement would just pick from that list.
Yeah.
I'm getting nods.
Yeah, and we did have, when we were hearing Senator Serval's bill, and he does support going forward with yours as pretty much the House version today, rather than conforming it to his. He, had the standards in there and talked about the 98%, those types of things. So.
Yes, sir.
All right. Anything further? Anybody has any questions or anything? Comments? All right. Then the bill has been amended to have the Stewart amendment on it. Yeah.
Move to report as amended.
All right.
That'll kill it.
Yes, I did get that, but so I have that.
Okay, so move to report and then.
No, we're just going to handle it here. So. No, we're not re-referring. So.
Okay, good. Thank you.
Okay.
So move to report as amended.
All right. We have a motion to report as amended, and That was not on the finance list, so we'll vote on the bill, so. No, no.
Ayes 11, noes 2.
Thank the committee.
All right, ayes 11, noes 2, and that's the other one, okay. All right, next is delegate head, so.
Thank you, Mr. Chairman. I have three for you today, and the first one, House Bill 1289, some of the stakeholders have asked if we could have that go by for the week, because I'd like to.
All right. Is there a motion to pass House Bill 1289 by for the day? All right, a motion and a second. All in favor say aye. Aye. All opposed, no. Okay, we'll buy for the day.
Thank you, Mr. Chairman. And now we've got House Bill 99. House Bill 99 is dealing with the continuing education requirements for funeral directors. Currently, the requirement is for 1 hour per year on pre-need training, as well as 1 hour on their laws and regulations. And what this would seek to do is change that from an and to an or. Reason being that the pre-need issues change very rarely, and they end up taking the same class repeatedly, and so this would just change it to an or. The amendment that was added to it in the House from the originally filed version did add that it would be at least once every 3 years that they would have to take the class on pre-need. And
right.
Very, very simple bill, and that's it. So.
All right, any questions of the patron? All right, does anybody wish to speak to the bill?
If you're in the Zoom room and wish to speak in regards to this bill, please raise your hand electronically now. Mr. Chairman, there are no speakers.
All right, we got a motion to report. Is there a second?
Second.
All right, we got a motion and a second. If there's no further discussion, we'll vote on the bill.
Ayes 14, no 0.
Ayes 14, no 0. The bill is reported.
Okay, thank you, Mr. Chairman. And now we go to House Bill 1269, staying at the funeral home. This also deals with pre-need, but this is dealing with the pre-need insurance. Currently, there's a class of pre-need insurance that is in code required for the payment of the premiums to yield a return of either the greater of 5% or the current CPI. And that has been a real problem. We are one of only 2 states that actually had this, and I think we may be the last remaining state to have this as a requirement. As a result, the pre-need insurance providers have left the state entirely, with the exception of one remaining.
Mr. Chairman,
at the beginning
I
of
think we
session.
heard this bill already. Didn't we already hear this bill?
We had
Got a Senate companion for this bill? Oh, wonderful. So you already know the issue.
Yeah.
In that case, what I would add is that in the House there was the addition of an emergency clause, which if it would be the committee's will to add to take that up and continue with that. The difference being that we're down to just one provider, and they have said if we don't have the emergency clause, they will likely leave until this goes into effect. And just to keep some continuity, we'd like to have the emergency clause added.
Second.
All right, we have a motion to.
Mr. Chairman, just to jump in here, the bill already does have an emergency clause on it.
It's already there from the House. That's the only difference between the House bill and the Senate version.
All right. All right, we have a motion and a second to report. If there's no further discussion, we'll vote on the board.
Oh, Mason.
All right.
Still open if you want to do it. You can vote. You can, it's still open if you want to vote it for Evan. Oh, I got it. Okay. Ayes 14, no zero. Ayes 15, no zero.
Okay. All right.
Thank you, Mr. Chairman, members of the committee.
Evan is a yes.
What's that? Oh,
Oh, yeah.
yeah.
He's been Glenn Davis.
All right. Next, I have in the following order.
Mr. Chairman, Delegate Krizak had to go to judiciary. If you want, he's asked me if I can present HB 1065.
We'll come to that at the
okay,
end.
at the appropriate time.
Okay, we do right now. All right. The order is Ransone, Brewer, Davis, Keem, and Price.
Brewer's here.
And, oh, well, I don't know who's, I just went down as far as I can.
You got Brewer here.
Yeah. Yeah.
Let's do it.
Go before Margaret shows up, so.
907, sir?
Yes, go right ahead.
All right,
What
thank
bill?
House Bill 907, security fence bill.
Okay.
I'll wait for it to, oh, I'm sorry, 474.
474.
I'm sure I'll see you again next week then. Here we go. All right, sorry, Mr. Chair, I'll be quick. I know everyone's hungry. House Bill 474. It clarifies certain building and fire officials are certified to perform fire inspections. So basically, the genesis of this bill is we have people in state agencies and other places, they're going through double certification. So this is allowing them to do their job without going through additional certification because they're already certified to be able to do that.
Move to report.
All right. Is there anybody who wishes to testify on this bill before it's out of the room here? So,
If you're in the Zoom room and wish to speak in regards to this bill, please raise your hand electronically now. Mr. Chairman, we have one speaker, Eric Olson.
Mr. Chairman, thank you. I'm Eric Olson, Executive Director of the Board for Contractors at the Department of Professional Occupational Regulation. I just wanted to say that the agency and the administration support the bill.
all right. Thank you. We got a motion to report, and is there a second?
Second.
All right. Any discussion? All right. Let's vote on the bill.
Ayes 15, no zero.
Thank you, Mr. Chair, members of the committee.
All right.
I didn't think so.
Delegate Davis.
Thank you, Mr. Chairman. I love how we're in a generous and supportive mood, and I hope it continues. So this is House Bill 58. It's one of the favorites from Senator Mason when he was in the House. It's a wage floor bill, and this is a pretty simple bill. All this bill says is that no locality can mandate that contractors pay a wage floor or have to supply benefits over and above anything that's mandated by the federal government. Right now, the policies we have in place actually hurt our swaying businesses. It actually puts them at a disadvantage compared to some out-of-state large businesses, and this just gets rid of that practice for our localities and allows our smaller SWAMs to be able to compete more competitively again, Mr. Chairman.
All right. Anybody have questions of the patron?
Second.
All right. Wait a second. Don't get ahead of the train. So, all right. Yeah, that's how you get run over. But so,
No.
is there anyone who wishes to speak to this bill, either in favor of or against? So, you got someone behind you.
Oh,
so.
sorry. Good evening. My name is Lou Spencer. I reside in Corrette, Virginia. I'm the Assistant Business Manager with UA Local 5 Plumbers and Gas Fitters. I represent 1,900 plumbers and gas fitters, many living in Virginia and employed with our 60-plus signatory employers. operating throughout Northern Virginia. I appreciate all the work this committee is doing and has done. Now is not the time to turn back the small improvements we made to stabilize the construction industry and the construction employment in Virginia. We oppose this bill because it will have a detrimental effect on decent wages, self-funded medical and retirement savings plans, self-funded apprenticeship programs, and it'll have a detrimental effect on responsible bidding, quality construction, and if passed, it promotes the underground construction economy, notorious for wage theft and worker misclassification, thereby undermining legitimate contractors and state and local treasuries. We oppose this bill. It does not encourage industry, commerce, building, construction, nor does it improve the condition of the people of the Commonwealth of Virginia. Moreover, it will assign the undocumented, misclassified, and unrepresented and unlicensed construction workers to become wards of the Commonwealth. Please, for the sake of the Commonwealth, oppose this bill. Thank you.
All right, thank you.
Good evening, Mr. Chairman and members of the committee. My name is Randy Dillard. I represent Laborers International Union North America. This is a bill that is pushing back things that we progressed on to this day. 28 states all currently have this type of legislation in place, as well as the federal government, as well as 2 local governments. And we ask that you oppose this bill. Thank you very much.
All right, thank you.
If you're in the Zoom room and wish to speak in regards to this bill, please raise your hand electronically now. Mr. Chairman, we have 3 speakers, beginning with Vic Nichols.
Okay.
Thank you. I support Glenn Davis because I have an article that indicated the worst sufferers included small and medium-sized businesses owned by minorities, women, and veterans who just didn't have the resources the past couple of years to handle slowdown and forced closures. The study was carried out by researchers at the National Institute of Standards and Technology and the National Oceanic and Atmospheric Administration and revealed businesses run by minorities, women, and veterans, which they call historically underrepresented group-operated businesses, were dealt a much worse hand by the pandemic than other businesses. And this was also published in the paper in the International Journal of Disaster Risk Reduction. So actually, Delegate Davis is looking out for our minority, women, and veterans businesses. Please move to support this bill. Thank you.
All right, next.
Julia Newton, please unmute and begin your testimony.
Good afternoon, members of the committee and chairman of the committee. My name is Julia Newton, and I represent SEIU, and we oppose this bill and ask you not to support it for all the reasons that the other union, the other representatives of the union has stated. So SEIU opposes this bill, and we ask you to please do not support this bill. This bill is not good for the working families of Virginia. Thank you.
Thank you.
Jason Parker, please unmute and begin your testimony.
Thank you. Thank you for letting me speak, Mr. Chair. Yeah, Virginia Building Trade, state of Virginia, we oppose. Local politics is good politics. Those localities should decide for themselves. Thank you.
Thank you. All right. Are there any discussion, any questions? All right, the bill is before us. Is there a motion?
Move to report.
Second.
All right, we got a motion and a second to report.
Substitute motion, PDI.
All right, we have a substitute motion for PDA
Second.
and a second to that. So we will vote first on the substitute motion to pass by indefinitely if it fails.
I got Senator Pike now, so I think I'm good.
Yeah. All right, we'll vote on the board. Yeah.
Ayes 8, noes 7.
All right, close.
Thank you, Mr. Chairman.
All right. Delegate Keem.
Thank you, Mr. Chair, members. This is a bill, House Bill 702, was brought to me by the town of Vienna. But before I start, if I can ask whether the mayor is still online. She was online a couple hours ago. She wanted to speak if she had a chance. Just wanted to see if she's still online. If she is, then I'd like to defer at least a little bit of my time to her. Mr. Chair, members, the genesis of this bill is that town council, as part of their legislative agenda, has been dealing with a lot of homes in our area. I'm sure many other localities where you have these older, smaller homes that are on larger lots, torn down and replaced by larger houses, and the houses are pretty large themselves, and they already take up most of that lot. What they're doing now is after they purchase it, they'll come back to the town and ask for extensions and building a deck or whatever, and it goes beyond the lot coverage. And so the idea was to see if there's some way to let the homeowners know that you need to check the zoning rules and such before you come in. We compromised, working with our realtors in the room. We worked out a compromise where this language, instead of being a disclosure, will be part of the due diligence. So it just simply adds another paragraph in the due diligence language. That's what the bill does. But again, I'm happy to answer any questions, or if there's an opportunity for the mayor to just speak for a couple of seconds, that might be good too.
All right. Is there anyone here who wants to speak to the bill, either for or against?
If you're in the Zoom room and wish to speak in regards to this bill, please raise your hand electronically now. Linda Colbert, please unmute and begin your testimony.
Okay. Okay. Hi, everyone. Linda Colbert, Mayor of the Town of Vienna. And thank you, Delegate King. We have very strict lot coverage rules in Vienna. And so exactly what Delegate King said, people will buy a house, we have expensive land, and so they build out the house to almost the lot coverage. And then someone will say, for example, they want to build a patio. And so this is, the town attorney and I worked with realtors and we agreed to put in this bill. And it's a good bill. It doesn't put unduly burden on sellers or realtors marketing properties. And I think it was, everyone agreed that it was a good bill. And so that's why it was ranked number 2 on the buyer beware disclosure list. And so, we just want our residents to understand what the lot coverage rules are, and then it will prevent issues down the line, further down the line. So if you have any questions for me, I'd be happy to answer them. Thank you so much for letting me speak today.
All right. Anyone have any questions for the speaker there?
Mr. Chair.
All right. Senator Stewart.
You should get used to saying my name. I ask so many questions. Delegate Keem, I'm just curious, because what you're suggesting here is the law. Caveat emptor, buyer beware, do your own due diligence. So would this actually insulate someone if they, and I assume that the realtor's going to have to do this because the person's not going to know to have this disclosure, but I'm just curious, if somebody is standing out there with the buyer and says, oh yeah, you can expand over there, and they buy it on that premise, which would be fraud, does this then insulate them from it?
Mr. Chair,
it's a written document that says no representation has been made?
Yeah, Mr. Chair, I'd answer the senator that I don't know if that would be a case where there'd be legal insulation. I mean, that's a different conversation, obviously, between two parties. But this is a practice that is already in the code with there are about 8 or 9 different categories already that has this kind of disclosure, so it would be treated the same way. So, for example, one right below that talks about the parcels being adjacent to other parcels, and you need to zoning classification. So there are many different ways that we want to make sure that the public is educated, and if they fail to follow the due diligence, they really don't have much recourse. And I don't think that this would provide any kind of immunity that goes above beyond what the current law is. We do have some professionals from the real estate industries, if there is somebody else that wants to answer that, but that's the best of my knowledge.
All right. Is there anyone who wishes to speak to the bill? All right.
Mr. Chair.
Yes.
I just had a quick question
Senator
about
Kagan.
waterfront properties and people that are wanting to build docks. I know in Virginia Beach, especially, get the permission, from the Chesapeake Bay Authority to build. Would this impact that, them if the Chesapeake Bay Authority approved, but it wasn't in, I don't know, some disclosure? I mean, I just want to make sure that the waterfront properties there are not impacted by this.
Sure, Mr. Chairman. I'd answer the Senator. I don't believe that our language would cover waterfront language because we're talking about lot sizes and lot lines. And I mean, I'm not familiar enough with your district as to know whether the water is considered part of the lot or not. So if I don't know that. So, but I don't think that would be. So I don't think that that's a problem. But
Yeah.
well, yeah. But thank you for the question. And obviously, if anybody else wants to answer that from a legal perspective, I'd be happy to defer my time.
All right. You want to?
Mr. Chair, Erin Barton with the Realtors, just going to say we did work with the town of Vienna and Delegate Keem on this bill, and we do support it. I think he answered the questions that were asked, but I'm happy to weigh in if anyone has any other questions.
Well, the question was the last one by Senator Kiggins on waterfront property.
Yeah, this, Mr. Chair, this paragraph that we're adding doesn't have any effect on waterfront property per se. It's really looking at lot coverage and zoning setbacks and lot lines. So, if they define their properties that way in her district, then that would be one thing. There is a separate provision in the buyer beware form that deals with Chesapeake Bay preservation areas. But the form itself is not a disclosure per se. It is a form that by law has to go to every buyer, just making them aware of things that they should be looking at before they purchase a property.
All right. All right. All right. A motion to report and a second. If there's no further discussion, we'll vote on the board now.
Staying.
Ayes 12, noes 1, abstentions 2.
Thank you, Mr. Chair. Thank you,
All
members.
right. And just so everybody knows, here's the breakout for the rest of the meeting. Price, Runyon, Hudson, Willett, and Krizek, or whoever's representing him. So.
We have way too many bills.
We got a lot of bills to carry. I don't want to be here till midnight next week. So, all right, Delegate Price.
Yes, Mr. Chairman and Senators, I have House Bill 802.
802.
And just very quickly, one of the issues that several of us have been working on is the inexcusable living conditions that some are experiencing across the Commonwealth. Some even have been highlighted in local news stories. In the district where I serve in Newport News, a lot of our constituent services work is based on the issues of housing, and so that's what really got us to this bill. Some of the wonderful residents I have the pleasure to serve invited me into their homes, and really what is happening is unconscionable that none of us would ever have to go through, but for the fact they are low income. They have issues such as rodent and insect manifestations, mold, mildew, flooding, and leaks, to name a few. And what basically exacerbates the situation is that if you put a heat map of people that are experiencing this, along with the increased incidences of child asthma, that these kids are missing a lot of school and have even increased costs to medical expenses because of their living conditions. So what 802 would do, right now, the landlord can get fined and the property can be condemned. Neither one of those actually help the situation that the tenant is going through. So 802 would allow for localities to enact legal action against the landlord to actually get the change in the living condition, which is what the tenant really needs. So this bill would help them force compliance with the health and safety standards of the VRLTA and really allow for localities to protect their citizens. And so this bill is supported by the Virginia Poverty Law Center, the City of Newport News, AOBA, VAMA, and the Virginia Coalition for Immigrants' Rights, which is over 30 organizations that I could list for you, but I think you could just believe me. Okay. Okay. And that's the bill, Mr. Chairman.
All right. Any questions of the patron? All right. Does anybody wish to speak in favor of the bill?
If you're in the Zoom room and wish to speak in regards to this bill, please raise your hand electronically now. Mr. Chairman, we have no virtual speakers.
All right.
I'm Jerry Wilson with City of Newport News, and as the delegate stated, we do support the bill. Thanks.
Okay, all right, thank you.
So, Mr. Chairman.
Yes, Senator Mason.
We wrestled with one forever the other day trying to figure it out. And this bill, you were going after the bad actor landlords. And you've worked with the Poverty Law Center and the apartment in the association, and the two sides are in concert and working together with you in advance of this bill. Is that correct?
Yes, miracles do happen, and this is one of those bills.
Well, Mr. Chairman, congratulations. This is great work. This is exactly what we were talking about the other day that we need, and thank you. Great job.
Mr. Chair, move to report.
All right, we got a motion to report and a second on that. And this doesn't have to go to. All right, we're fine. It's not going to finance, so I just had to check that out. So, all right, we will vote on the board now. So. Yes. All right.
Kiggins. Ayes 14, no 0, abstentions 1.
Thank you,
Mr. Chairman. 0. All right, thank you. And the Runyon, yeah, come on. So, yeah.
Good evening.
Yes. Yeah. Yeah.
Good evening, Mr. Chair and committee. Good to see you all. Yes. I have, excuse me, House Bill 1287, which is an interesting bill. It's a recycling bill that encourages industry and the private sector to figure out how to recycle more. So it takes product out of the waste stream. It'll help the Commonwealth use more post-consumer content recycling. Okay. And to be honest with you, I'd like for you to notice that this is a bipartisan bill and that Delegate Lopez is my chief co-patron on it.
Oh.
So perhaps I misread the room. I apologize.
You'll withdraw that comment, so.
As a smart person would say.
Thank you.
All right, does anyone wish to speak either for or against the bill? So.
Hello, Mr. Chairman, members of the committee. I'm Mike Carlin with Access Point Public Affairs on behalf of the Coalition for Consumer Choices. It's an association of 5 regional chambers of commerce and about 10 statewide associations, all in support of this good bill. Thank you.
Second. All right, if there's nobody else to speak, we got the motion here, motion and a second to report the bill. No further discussion, we'll vote on the board now. All right.
Ayes 15, no 0.
15 no, so. Wow. All right, Delegate Hudson, so.
Thank you, Mr. Chair and members of the committee. I have House Bill 1286.
All right, 1286.
Thank you, Mr. Chair. This bill streamlines the process through which redevelopment and housing authorities notify residents before selling or demolishing public housing units. The current state code provides that tenants get 12 months notice before an application for demolition can be filed, but these days HUD can take several months after that to process the application, so the total process takes much longer than 12 months. What this bill would do is allow the tenant's notice period and HUD's application processing to proceed concurrently, so that tenants will still get at least 12 months notice before they have to move, but only 6 months before the application is submitted. In short, the bill will expedite the total redevelopment process without shortening the intended existing standard of notice to tenants. The bill is supported by the Virginia Association of Housing and Community Development Officials and the Virginia Poverty Law Center.
All right, are there any questions of the patron? All right, is there anyone who wishes to speak either for or against the bill?
If you're in the Zoom room and wish to speak in regards to this bill, please raise your hand electronically now. Mr. Chairman, there are no virtual speakers.
All right, no speakers. Bill's before us.
Second.
All right, we got a motion and a second to report the bill. We'll vote on the board now.
Ayes 15, no 0.
Ayes 15, no 0.
Thank you, Mr. Chair.
Bill's reported, so. Yeah.
3 votes per hour.
All right, Delegate Willett.
Thank you, Mr. Chairman. I'm going to try to give you a simple bill to finish things out this evening. I've got HB 400 before you. This bill, relatively simple bill, it adds the rental assistant demonstration program, it's called the RAD program, to the established tax assessment guidelines for affordable housing in Virginia. Just to summarize, Virginia, when they assess properties in certain affordable housing programs with rent restrictions, the law requires these properties to be assessed using an income-based approach that takes into account the reduced rental stream. The list of federal programs in the current code section was created in 2006. The RAD program was created by Congress not until 2012, so it was not included. This bill simply adds it to that list.
All right. Are there any questions of the patron? All right. Is there anybody who wishes to speak to the bill?
If you're in the Zoom room and wish to speak in regards to this bill, please raise your hand electronically now.
All right. Nobody to speak. All right. We got a motion and a second to report. We will vote on the board now. Senator Stewart, you there?
15 ayes, 0 noes.
That's right.
Thank you, Mr. Chairman.
All right, 15 to 0, the bill is passed and reported straight to the floor. So,
Great, thank you.
I think somebody said Delegate Krizek was tied up.
I've got it.
Okay,
Mr. Chairman.
Bell.
It's a pretty simple bill. It's a Section 1 bill, directs the Department of Housing Community Development to convey a stakeholder group to develop, 1065, sorry, develop a sample manufactured home lot rental agreement in accordance with the requirements of Virginia Manufactured Home Lot Rental Act, and sample manufactured home park notices regarding an intent to sell. This was an oversight. Area just wasn't identified in the code, and this bill seeks to address this in a similar way that other areas are addressed in the code.
All right. Is there anybody who has questions of the stand-in patron? So, yeah. All right. Anybody wish to speak to this? All right. We're fine. So,
Mr. Chairman.
all right.
Mr. Chairman.
Yes, Senator Hedgeman.
If I could just add also that I did have a budget amendment that spoke to this bill, and that budget amendment was approved by the Finance Committee.
We took care of you. All right. Does anybody have a motion on this good bill? So.
Second.
All right. All right.
Yeah.
All right. We will vote on the board. All right.
Ayes 15, no 0.
Ayes 15, no 0. That bill is reported, and with that, we are adjourned, and we hopefully won't be here till midnight next week.